Well,
Thank you, sir.
what do we owe this pleasure?
Ask the question.
Have a good day, Vince. Hey, unrelated to a case, I'd like to talk to you for a minute. Do you have a second or not? You in the middle? Oh, you go ahead and finish that. Just come on in whenever you get a minute. Unrelated to a case. Okay, thanks. Bye. Bye.
I told you that's ran down.
Yeah, okay. Well, I could sit out here and do nothing. Would you run that down to Jennifer? Mohammed, can you hear me? Yours is at 9:15. How about yours, sir?
What's your name, sir?
Salvador Cabinti.
Same.
It's under Rivas.
Yes, sir.
It's
Salvador Enrique. I don't know why he put that name like that, but yeah.
It's 9:15, so I'll have the same on for Ireland.
okay. So you guys are early. Good to see somebody early.
48 or something.
Huh?
I know the street became a one-way, started boring. I was running with my sorry.
Nice suit, by the way. Nice coat. Good morning, counsel. How are you?
Oh, there we go. Good, Your Honor. Thank you.
Good morning, detective.
Good morning, Your Honor.
People against Lexi Jane Elaine Don, T 25B724898. Ma'am, you can state your name, please.
My name is Lexi Dan.
Counsel, your appearance.
James Jeremetta, P60260, on behalf of Ms. Dan.
I don't think you guys ever signed this, did you?
Your Honor, I sent a signed copy. I emailed it into the court yesterday afternoon. It's got my signature on it, and Ms. Dan signed a copy and sent me a photograph. So I sent that as an attachment to what I emailed in. I think I emailed it into, I can double check the email address.
Do we have that by chance, Lisa?
No, I didn't receive it.
Where did
I'm
you
sorry,
send-
I sent it to Heather.
Can you see if Heather?
I'll check with her.
Okay. So while we're doing that, let me just go over this right now. So all right, so defendant would plead to OWI occupant less than 16, which is a 1 year. She would plead to child abuse in the 4th degree. Am I understanding that correctly?
That's correct, Your Honor.
And then the rest of these charges will be dismissed?
Correct, Your Honor.
All right, let me just double check one thing here. Hate to do this to you. Just don't like this. Poland mystery.
Hello.
Can I see you in here on this Lexi Dam case? Thank you.
Yep.
I'm going to explain it when he comes in here, okay? Good morning.
Of course.
Good morning, Your Honor. Mohammed Ben Abdi.
Come on in. Thanks. So you're adding a charge of child abuse in the 4th degree. She would be pleading to OWI occupant less than 16, and then the remaining charges to be dismissed. I have to impose minimum 60 to 90 days jail with work release if she's eligible. It says the condition may be waived at the discretion of the court if the defendant completes a specialty court program. So I want to make sure we understand one another in that aspect. I am not under no obligation under this sentence agreement to impose immediate jail.
Correct. It would just be a recommendation.
Okay, now this one bothers me at the end. What do you think I'm going to talk to you about? If the defendant fails out of the sobriety or specialty court program due to poor performance, commits another crime while on probation, or the judge finds sufficient cause to terminate probation, the balance of the year or 1 year must be served in jail, no work release or waiver. Again, I don't want to argue with you guys, but you can't tell me what to do on a violation of probation. Let's say somebody's really tried and they've struggled and they can't get through. I don't want somebody telling me you have to give a year based on this language.
Yes, so Judge, I would say that it's just a strong recommendation.
Well, then let's take it out. Can we take it out?
Is it okay if we just write recommendation in regards to those terms?
Yeah, if you want to write down on the bottom, the above are just simply a recommendation, especially. Tell you what, I'll write it down. How's that? Is that okay?
Yes.
Okay. Second here, guys. I'm so sorry. I'm gonna write it out and then I'm gonna repeat it to you, okay? All right, so I would just add out this. The above are recommendations only. The court need not order 1 year in jail if the defendant does not successfully complete the program. They can't tell me what to do. I don't know. Do they do this with circuit court judges downtown? Tell them if they violate, then they have to do this. I don't understand. I still never have understood. If you don't feel like you can do it, They can go up north here to Detroit, go in their program. You can have these conditions. Maybe that judge will be happy to do that. But I can't in good conscience sign something or agree to something that I'm not prepared to do. And I'm not prepared to say at all costs that if somebody doesn't complete the program that they have to do a year. I just can't in good conscience do that. I wish people would be more involved in sobriety courts, and then they would understand that these people are struggling, a lot of them, and they do the best that they can. And if they get to the end and they just can't make it because they've fallen off the wagon and I have to terminate, I'm not going to give them a year. And that it's that simple. So I don't know what you want me to do. I'll be happy to take a waiver. I'll be happy to include this language on here, but I'm not going to commit to give a year. Like I've said to you guys repeatedly, you don't tell circuit judges what to do. You're going to tell me what to do. And you have a probation violation. You're not the judge. I mean, you're overstepping your bounds. If you don't think you can sign it, I understand. Send them up there. They can take a waiver today. But I'm trying to, this is not fair to this young lady for me to agree to this.
And I understand, Your Honor. Unfortunately, I have no discretion.
Okay, so you tell me what you want me to do. Do you want to take a waiver? Do you want to,
If the defendant is waiving their right to a preliminary exam, we would not object.
counsel, I don't know what to tell you. This is not me. I just can't in good conscience agree to something that tells me what to do if there's a violation, somebody's can't complete the program. I just can't do it. I will not do it. I cannot. And so I will adjourn this for a week, let you think about it. Ma'am, I'm not trying to hurt you. I'm trying to protect your interests.
I understand, Your Honor, and I do
just-
appreciate that.
I just think this is not right. And I don't care if every judge in the county does this other than me. I really don't.
I was
But-
very scared to sign it, so I do appreciate that a lot.
So that's what I'll do. Let's adjourn it a week. You can go back, tell your office. If what I'm saying, if they don't want to change, I understand. We'll either go to the exam next week or you can, they can waive and go downtown and the circuit judges can handle that. I happen to think our program's pretty darn good, but that's just me, you
I
know.
would agree. Whatever.
Well, it's not pretty darn good. It's very, very good as far as I'm concerned, but
Judge, I'll relay that in committee.
yeah, I'm not trying to argue with anybody. I just, life's too short and they just adjourn 1 week. What are we gonna do? November 25th?
Yes. Are we setting an exam?
Yeah, we're gonna have to set this for exam, guys. I'll tell you what, why don't we set it later in the morning, Lisa, like 11? And if you guys work it out and you want to show up at 9, I'm gonna be here, or 8:30, whatever the case may be. I'd encourage you to watch that language, Mr. Garamita. I know what you're trying to do, and I'm not criticizing you in any form or fashion. It just
No,
begs the, I don't know how many felonies do you do? I wonder, are they trying to tell circuit judges what to do? On probation. On probation. They can't do that. You're overstepping your bounds. That's not the prosecutor's province. But I get it. You guys take care of it. We'll see you next week at 11. If something else happens before then, that's fine. Thank you very much.
Thank you, Your Honor.
Thank you, Judge.
Premier Truck Sales, 25SO27227.
Judge, he's in a breakout room with the prosecutor.
Oh, they already got the file in here and with the reduced fines.
Yeah,
Unless
he had
it's-
several cases today. He also had priority waste. So I don't know if they're
Okay.
still talking.
Yeah, okay, let me go on to Kenneth Moore. Come on up here, sir, 25M618494A and B. Hi, your name? So you're charged with no multiple licenses. You have the right to a lawyer. You have a speeding here too. You want a lawyer? So it's up to you, whatever you want. If you want a lawyer, I'm going to give you one. Okay, we'll set you up with a lawyer. I'll put that one there. You can go out in the hallway. Just be patient. It'll probably be a few minutes, okay? Blue Jean Dickerson. Is Lou Jean Dickerson here?
You get a note on.
No, not on Zoom.
You have a note on this one?
I did?
Don't worry about it. Maybe nobody showed up on this.
Oh, yeah, that was
No.
if I throw a thumb.
Is Trooper Brown here, Lisa? Trooper
No,
Brown?
not on Zoom.
All right, Lou Jean Dickerson Jr., 25 M60845 A and B. All right. Neither the plaintiff, the officer, or the defendant appeared. I'm going to go ahead and dismiss the case. Both of these. There's a limited access. And then there is a no proof of insurance. Okay. Okay. Now, Scraziani, do you have?
Good morning, Judge. Judge, I have Everett Ridenhour and I need the discovery, but I'm going to be asking, this is a pretrial obviously, but I'm going to be asking for a personal bond with a tether on his
Is
behalf.
that Mr. Reinhauer here?
Yes,
He's
Your
in
Honor.
the interview room. He is there, sir.
Okay, do we have the file? Did somebody bring the file in?
No, let me bring it in right now, Judge.
People against Oleg Benro Michael Oladipo, 25M608460. Again, this is Trooper Brown. I don't believe, is Mr. Oladipo out there, Lisa?
Coming in right now.
How you doing, Mr. Oladipo? Your name?
Oladipo, good morning, Your Honor.
Good morning to you. You're looking awful sharp there.
Well, this is my first time doing this, so
Well, that's a good thing. If you get to court often, you're either a criminal, a police officer, a lawyer, or a judge. So that's good. Listen, the officer showed up. Appreciate you, or failed to show up. Appreciate you dressing up like that. Your case is dismissed. I gave him 15 minutes. Have a great day. Thank you.
thank you, sir. Thank you, Your Honor.
You're welcome.
Wow.
You can go, Mr. Oladipo. You're all set.
Thank you.
You're welcome. Good to see somebody smiling in here besides me, Mr. Graziano.
I don't see a pay form in this room now.
People against Everett. Scott Ridenhour, 25B704540. Your name, Mr. Graziani?
Good morning, Judge. For the record, John Graziani, P number 43387, Judge. Judge, this is an alleged incident the alleged incident is from.
Hang on one second. Mr. Ridenhour, can I have your name?
Everett Scott Ridenhour, Your Honor.
I already arraigned him. You know that, right?
I wasn't aware of that, Judge. I don't have the discovery. And at this time, Judge, I'm simply going to be asking for a bond reduction, $5,000 personal bond with a tether. He's been locked up. He was picked up by garbage picking. It doesn't even appear that he was aware of this outstanding warrant.
Who was handling this, Mr. Mohammed?
Mr. Mohammed is handling it, sir.
Hello?
Mohammed, I need you in here, please, on Ridenour. He's asking for a bond reduction.
Okay.
Well, you know, I'm just telling you why I did what I did here. I don't remember the specifics. Is the detective here on this case?
I believe it was Detective Toulage, and I saw her a few minutes ago. I don't know if she's streaming in over here, Judge.
I think this was the, your name,
Good morning, Your Honor. Muhammad Mohammed on behalf of the people.
he just wants to move for a bond reduction. I kind of remember I was advised that this was an ugly one. And he has multiple warrants. So he doesn't like to show up in court, but I'll let you argue your bond. Go ahead.
Judge, he has been sending money to his children who live up north with the biological mother, his former fiance. And like I said, if you know, regardless though, he'll have other matters to take care of and clear up. And that's all I'm stating at this time, Judge.
Anything, Mr. Mohammed?
Yes, Your Honor, we would object to modifying bond. I don't believe there's been any changing circumstance.
No, there hasn't, and I agree with you. He's got all kinds of warrants, and this one bothered me. Mr. Ridenour, you can't
Explain yourself,
ask
sir.
me for a personal bond when you don't show up in court. You have a history. You can raise your hand all you want. I'm not changing my mind.
No.
You can't fail to show up in court, and you have about 8 warrants.
Wow.
What? I'm not going to stop you from talking. I'll give you.
I just respect him on red lane. Your Honor, when I went to court last time and I got these warrants, it's because I was took up north and I was incarcerated. Now I wrote habeas corpus to all these, and I was under the impression that all these were taken care of, except for Brownstown. I did not know Brownstown even existed. But as far as Taylor and Rouge, them are driving, Your Honor, and I did fill out the appropriate paperwork to try to get them handled. And when I left up north, it was not a warrant. So all this, all this just came to me when I got this arrested. I'm not ditching court, I promise. I understand your decision. I don't want you guys to think I'm just an outlaw. You know,
Nobody said anything about anybody being an outlaw. You got 8 warrants, 2 in Charlevoix, and 6 others. I'm not going to change my mind. Bonds continued. I can give you next Tuesday if you want, Mr. Graziani, or do you want the following Tuesday?
Next Tuesday would be fine, Judge. Simply
We'll
need a
make-
discovery.
Okay, we'll make it the 25th. At what time, Lisa?
9:15.
At
Thank you,
9:15 in the morning. Thanks a lot. Good luck, sir. Thank you.
I'll talk to you later, Mr. Ridenour.
Thank you.
You guys have a good day.
Thank you.
Am I free?
Yes, sir.
All right, thank you.
Thank you.
Mr. Graziani, you have the next one in custody too, just so you know.
Yes, let me, in fact, have the opportunity to talk to, let me see, it's Banks I need to speak with.
Okay.
Thank you.
Okay. Salvador Enrique, come on up here, sir. The officer's here. 25 M613784. So we're going to bring in Trooper McLaughlin on this one. Good morning, Trooper. Your name, sir? Trooper McLaughlin? Your name, sir?
My name is Salvador Beatty.
Good morning to you, sir.
Good morning, Your Honor.
Good morning, Your Honor. Daniel McLaughlin.
How are you, Trooper? What do you want to do on this one?
I'd be willing to do 6 to 10 for this gentleman.
Okay. Do you want to plead to 6 to 10 over would be 8 point. So-
Please,
You were going 93. I mean,
yeah. I'm just trying to avoid I was driving with the traffic and it was a big truck push me.
was this a commercial vehicle?
Yes, sir. Please, they're gonna, I'm a support of my family, Your Honor, please. I can pay the ticket, but if you can reduce the point, please.
I can't do anything about the point, sir. Is there anything else you think, or is that the lowest you're gonna go, Trooper?
Well, Your Honor, with all due respect, Mr. I don't know how to pronounce his last name. So Mr. Salvador, from what I understand, also came into the court and gave your court staff a problem about the citation. And I got a phone call regarding the matter because he didn't feel like it was justified. However, I am showing this.
Hang on a second.
Yeah.
Did you do that?
I did what? No, I just called.
Wait a minute, slow down. Let's just have a conversation. Did you come in here and give the court staff a hard time?
No,
Did you come in here and talk to the court staff before today?
no.
Called,
Lisa-
Judge. He didn't come in person. He called.
Okay,
Oh, my
what-
apologies.
What did you do? What did you say when you called?
No, I called just to know how about the paperwork.
Was he nasty, Lisa?
Yeah, he wasn't very pleasant, and I did have to call the officer just to verify a couple things on the ticket.
One of the things I don't understand. I don't understand why this poor court staff down there gets this kind of grief. They don't deserve it. They don't deserve it. I don't understand it. I don't know why people think they can do that. It's so disrespectful. So incredibly disrespectful. Why would somebody call up and give the staff a hard time? I can't figure that one out. What did the staff do down there to write this? Listen. That's just a bullet. That's just a bullet. You call up and you give a bunch of women a hard time down there because you don't like the fact that some trooper wrote you for going 93 in a second. And you know what? That is just not right. Now, here's the good news. Here's the really good news. You can go down there and apologize to them when you're done.
Yes, of course. I mean,
Yes, of course.
it's my job, sir.
You don't have the right to call up and give the court staff a hard time.
No, but
Did you hear what I said? They didn't write the ticket.
my DPO.
Stop. Trooper, the staff is better than that. You're better than that. And I'm better than that. So I'm just going to tell you this. I would like you to do what you would do if he was pleasant to the court and the staff and to you on the road. If that means this is the best you can do, that means this is the best you can do. Because we don't want, because we're better than that, and we're not going to hold somebody's ignorance against them or lack of civility against them. So I'm going to leave it to you. If you look me in the eye and say, Judge, this is the best I do, even if he was nice on the road and apologized and nice to the staff, that's one thing. If you can't say that, then let's just give him 75 and a 70 or whatever you want to do, and we can go from there.
Your Honor, the best I can do is what I've offered, 6 to 10. That is the best.
So that's the best he can do, and I believe him. He's not going to lie to me in court. So that's the best he can do. And you know what? That's all you can do. But you can't come in here and give people a hard time either. But that has nothing to do with this decision. Nothing to do with this decision. So you can either plead to 80 and a 70, or you can go to hearing on it, whatever you want to do. Sir, it's not my ticket. You were really going fast here. Nobody here is trying to railroad anybody. That's the best he can do. I'm not the trooper. I'm just the judge here, okay? That's all I am. They control their ticket. I don't. So that's it. You can either take the plea to 80 and the 70, or you can go to a hearing.
With the 8 points?
What's that?
With the 8 points?
It would be 1 point.
1 point from the license?
1 point. Yeah, 1 point.
And the ticket.
I'm sorry?
And pay the ticket.
Yeah, I'll ask you how you plead to 80 to 70, and then I'm going to fine you.
Okay.
To the charge 80 and a 70, you plead responsible or not responsible?
Yes, sir.
You plead responsible?
So if I don't understand, I'm so sorry.
That's okay. You're going to get 1 point.
I'm a little confused, sir.
Well, I don't want you.
I'm not a criminal. I told you.
Nobody said you were a criminal. Did anybody here infer you were a criminal?
I don't want to lose my job.
Sir, I can't do anything. I can't do anything.
So
If you plead to 80 and a 70, it's 1 point.
so 1 point and $70 ticket.
$70?
No. I don't know.
I don't know. I'm going to look at your record when I'm done. Boy, your negotiating skills, huh? You could have gone to law school.
No. I'm just, I don't understand.
Well, come on, you understand. We've covered this.
Yeah.
Come on, what part don't you understand? I got a bunch of people waiting here. I don't want to be rude. I don't want to cause you to do something you don't want to do. What do you want to do? I got to move this case. You either plead to 80 and 70, we're going to have a hearing right now. I'm going to swear him in, swear you in, and we'll go from there.
Yeah, I thought the 1 point and
To the charge of 80 and a 70, do you plead responsible or not responsible?
responsible.
I'll accept the plea. $185 is your total. You can go down the hall and take care of that. Good luck to you. Thank you.
Thank you so much. I hope they.
Be nice to them down there, will you?
Yeah, of course.
They don't, no. They don't deserve
I
it.
called for them so much, I know, but I'd never be disrespectful at all.
They wouldn't tell me that you were disrespectful or not pleasant if you were nice and respectful. They know. I would never put up with that. Come on. Enough. Good luck. Premier Truck Sales. 25 SO27227. You're all set.
All right, thank you, sir. I'll leave that.
2. Thank you. Trooper, do you have another one?
Yes, Your Honor. It appears I have 3 today.
Okay, Mr. Dillon, you ready on these? Let's go on waste management. Waste management, 25 SO23347. Who has
I'm ready,
waste
Your Honor.
management?
I
You
have
have
Carrie
what?
Barrett. Yes, Your Honor.
Okay, your appearance?
Carrie Barrett with Lacey and Jones. My P number is 42711.
Okay, you're going to plead to overweight, agreed upon fines and costs of 3,800. True?
That is true. Would plead responsible, Your Honor.
I'll accept that plea. $3,800 fines and costs. I'm going to just give them until December the 18th to pay. Okay?
That would be great. We appreciate that, Your Honor.
Have a great day. Thank you.
Thanks, you too. Have a nice holiday.
Thanks, you too. Premier Truck Sales, 25 SO27227. Good morning, Mr. Dillon. Your appearance?
Good morning, Your Honor. Alex Dillon on behalf of Premier Truck Sales. Your Honor, we've pre-tried this case and agreed to pay $1,333. If you could
To that charge of overweight on behalf of the company, responsible or not responsible?
Responsible.
I'll accept the plea, $1,333, paid by December the 28th. Priority Waste LLC, 25 SO24454B.
Good morning, Your Honor. Alex Dillon on behalf of Priority Waste.
What are we doing on this one?
Your Honor, the remainder of the cases, we've pre-tried them. I've talked to the prosecutor, and we would like to schedule formal hearings.
You guys are killing me on this. How many times have you know how many times I've adjourned this? This is a defective equipment.
Well, they're all overweights, actually.
Not this one.
4
Priority
cases,
Waste.
Judge.
What's that?
There's 4 cases.
There's an A, B, and C, and then another one.
Jeez. Why are you guys calling? What is going on these? Is it time again to pay? I mean,
No.
you guys were here on October 3. We set it for October 21. We adjourned it to November 4. We adjourned it to November 18. Why are we doing this? If it's a question of needing time to pay, I'll be glad to give you that, but this ticket was written September 30. It's not your problem, and I didn't write these. We're supposed to have 90% of these adjudicated within 35 days, 98% within 56 days, and that would put this one already in the 2% range. I didn't write these rules. They didn't confide in me before they did it. You know what I'm saying?
Yes,
I don't understand this whole thing, but I try to follow the rules just like everybody else.
Those are all priority ones, too.
So what do we do? Come on.
Okay,
You guys can resolve these, man.
this one, if you'd like, I can go back and talk to Mohammed. The remainder, I do not believe the remainder are in the same procedural position that, although this one might be.
Say again, what?
454, we would definitely schedule a formal hearing.
Well, why didn't we schedule the formal hearing a month ago?
That I don't know. I didn't handle it.
Do you have a defense on this? I mean, just come on.
Yeah, Your Honor, we've got, these are residential trash trucks trying to take out the community's trash, and they're targeted by these sheriffs who are weighing them wrong and pulling them over for things that don't happen. We have valid defenses, and
all right, okay, good enough.
we have 3 sheriffs that are just, you should see us in Taylor. I mean, we had to talk to the mayor. I mean, it's tough. It's very difficult to do our job when we're being dragged to weigh stations.
Fair enough.
Thank you.
All right, so I'm going to set 25SO24 454 A and B for hearing. Is there any reason we can't do this next week?
What's Thanksgiving?
Well, I don't mean on Thursday. I mean on Tuesday. I mean, you got.
Mohammed indicated that he would prefer not to do them next week.
I love this country. Call me Mr. Money, will you? Mr. Kenny, I wish you could have done this job for a few years. Mr. Kenny and I went to law school together.
Good morning, Judge.
And then you hear this kind of, I don't know what to say. Let me get Mr. Money. I think you were the star of our class, Mr. Kenny.
Oh, come on. I thought that was you.
Really good to see you. I mean it.
Yes, sir. Good to see you.
And when you get here for an exam, I'm buying you lunch after the exam, okay?
That's today, Judge, this afternoon. But
Is it?
Yes, sir.
You're doing one this afternoon?
Yes, sir. I'm doing one
Okay.
at 1 o'clock.
Today is not great, and I'll tell you why. Mr. Muhammad, your name?
Good morning, Your Honor. Muhammad.
What is this that you don't want to do a formal hearing on Thanksgiving week? Is that what I understand? How long have you been a lawyer? How long have you been a lawyer?
2 years.
2 years. Wow. I can't imagine another 3 or 4. You're going to be figuring out where it's going to be done. I'm just teasing you. Is there a reason you don't want to do it next Tuesday?
No, I'll be here. It's just we try to limit 4 days or the job day on
Let's just stop the quibbling here. Let's do it 2 weeks from today, Lisa.
December 2nd,
That's formal hearings. So
At what time?
December 2nd at 8:45.
Okay, so that's, I just want to make sure we're setting all these for December 2nd at 8:45, and then I'm going to go through the rest of these. I don't know what we're doing on the rest. I haven't even opened up these other files with Mr.
So there are set for formal hearings. I think there could be 6 or 7 formal hearings.
So we're going to set them all for,
Right.
so you guys can't resolve any of these?
Leave that for the defense counsel.
Well, I understand, okay.
There was no discussion on them.
All right, let's go to, can you just wait right here a second? 25SO27230, A, B, and C. Counsel, your appearance.
Morning, Your Honor, Alex Dillon, P52648 on behalf of Priority Waste.
Do they stand mute, wait formal reading on the misdemeanor of spill load?
Yes, Your Honor.
So are we setting these for a pre-trial and formal on the other two?
I would request the bench trial. Defense has already, it does not appear we're going to come to any resolution.
What do you want to do, a bench trial, or you want to take it to a jury, Mr. Dillon?
Is this 346?
This is 230C, spill load, and then you got a defective equipment and oil leak. You want to set them for formal in a bench trial?
Yeah, I don't see a misdemeanor on here.
Hang on a second. I got 230 A, B, and C. You got a spill load, which is 25SO27230C. That's spill load. And then you've got overweight and defective equipment. Those are civil infractions, the last two.
I just don't see spilled load. There's an oil leak and it's got a check on the civil infraction and then there's a mark on the misdemeanor. So I don't know. Is it a misdemeanor or is it a civil infraction?
Oh, the last one is oil leak, it says. That they charged as a misdemeanor. That's what they're referring to. It will put into our computer as spill load.
Well, in this case, then I would ask for an order of discovery so I can get the videos, dash cam, weight report.
Okay, whatever you guys want. I'll tell you what, I'll adjourn this one a week. You guys can go ahead and get the discovery order together. And I'll just adjourn it a week and then we'll set it for a bench or whatever you want to do. How's that?
All right, thank you.
We'll adjourn this one to November 25th at 8:45, Lisa.
Yeah, that's fine.
All right, and then, so the civil infractions will go to that date as well, okay? Now I've got priority waste, 25SO24455 A and B. And that's a misdemeanor. We got another misdemeanor, spillage, that's file B. Does your client stand mute, waive formal reading on that?
Yes, Your Honor.
All right, and do you want a formal hearing on the other?
This, I see spillage, but I don't see any mark on whether it's a civil infraction or a misdemeanor. I'd like a formal hearing.
Well, spill load is a misdemeanor, right?
Yeah, it looks like there's a mark. I don't know. It looks like there's a mark closer to the CI on the ticket.
All right, I'm adjourning this to November 25th. You guys can figure all this out. We'll set it at 8:45 again, right, Lisa? Is that okay?
Yes, that's fine.
And then I'm going to go ahead and set the overweight 25SO27229. We'll set this for a formal on December the 2nd. We'll also set 25SO23346 and 25SO27228. We'll set these for a formal on December 2nd at the same time I gave Mr. Dillon on the other one.
Okay.
And what time was that, Lisa? I'm sorry that I gave him the formal hearing on December 2nd.
December 2nd was 8:45.
At 8:45. Okay. That's what I'll do. And that should cover them all. So you have to come back next week, I guess. And you guys see what else. Are these true? So you're telling me these are going to go to a hearing though, huh?
Your Honor, my instructions are to defend these as aggressively as possible. I mean, you know what we're up against in your district. And
okay. Hey, listen, you don't ever have to apologize. It's if that's what you want to do, I get it. Why? I've never heard you say or anybody say that they're being unfair over there. I don't know. I mean, maybe they are, maybe they're not weighing things. I just never heard that, and that's fine.
Well, there is a safe haven under the law where you're allowed to disengage lift axles, and we're constantly being weighed with 3 axles when the truck actually has 5. And it's a question of fact of whether they're, yeah.
Good enough. Have a good day, Mr.
Thank
Dillon.
you.
We'll see you next week. Thanks.
Thank you, Mohammed. Appreciate both.
Donald Charles Miller, 25M586386. Okay, this is Trooper McLaughlin. Again, come on up here. And then I'm going to take Catherine Cersei. She'll be in with Trooper McLaughlin. And then Mr. Ellis, Guy Ellis. So you can have Cersei if you're here. Ellis, if you're here, have a seat at the table there. Trooper, your name?
Yep. Good morning, Your Honor. Daniel McLaughlin.
Your name, sir?
Donald Charles Miller.
Okay. Wow. He thinks you were traveling pretty quick here. You weren't having a heart attack, were you? What are you driving like that for? Trooper, what are you going to do on this one?
Your Honor, I don't have Mr. Miller on the docket today. I have 0 subpoenas for him.
Yeah, he's on 113 miles per hour and a 70 is what you wrote him for.
Oh, goodness. Okay. Would you mind providing the citation number so I can just get a quick review of that?
No
Just to
problem.
verify?
It's X458-6386. X458-6386.
Clear on that. Give me 1 second, Your Honor. I'll just
Take your
verify,
time.
okay?
Take your time.
Motorcycle.
What's that?
I was on a motorcycle.
That's even more dangerous. What are you doing?
Oh,
You
I
got a
remember
death
this. I
wish or
remember this traffic stop now. I just want to verify.
You got a death wish or something? What are you driving like a maniac on a motorcycle for?
Well, I was speeding.
Well, I know that. That's pretty clear.
Car behind me was speeding faster. I didn't know it was a trooper. And
The trooper was behind you, speeding faster than you. I think he was probably trying to catch up to you, probably.
Yeah.
Come on. All right.
I sped up to reload that space cushion.
Okay. That's kind of, all right. What do you, have you had a chance to pull that up yet?
Yep. So, yeah, I got him at moving radar at approximately 113 miles an hour when I did try to catch up to Mr. Miller. He obviously sped up. At first, I thought he was fleeing, so I didn't initiate a pursuit. But allegedly, Mr. Miller advised that he didn't realize I was coming for him. So when he sped up at the time was that the top speed that I got him at was 113. I mean, this one's a tough one, Your Honor. That's too fast, and I take motorcycles very seriously. I ride one as a cop. That's what I do as my summer job with the state police. And I think I advised that of Mr. Miller. God, accountability is important for me. I would be willing to offer the same thing to Mr. Miller that I did with Salvador, 6 to 10. That's the best that I can do.
It's a one pointer. You want to do that?
Sir,
To that charge, 6 to 10 over, responsible or not responsible?
I'm responsible.
$210.
Yes, sir.
Slow down. Okay, that's crazy. What are you driving like that for? You're going to kill yourself. Good luck.
Thank you.
Cersei. Catherine Lee Cersei, 25M607556. Your name, ma'am?
Catherine Caesar.
All right. And Trooper, your name?
Yep. Again, good morning, Your Honor. Daniel McLaughlin.
She's got a prior speed in 19, but otherwise clean. You got her going 87 and a 70 on laser. So,
Yeah. I did also already give her a break at 6 to 10 roadside.
Okay.
I'd be willing to do 1 to 5.
You want to plead the 5 over? That's 0 points. It will go on your record, though.
Yeah.
I can't hear you.
Yes,
To 1 to 5 over, responsible or not responsible?
responsible, Your Honor.
All right, $165. Please accept it to 1 to 5 over. And I'll dismiss the original charge. 165 down the hall. You can make your payment, okay?
Thank you.
Best of luck. Ellis, Guy Lincoln Ellis Jr., 25M608583. Good morning, sir. Your name?
Guy Ellis.
All right, you got him going 88 and a 70. It looks like he's got a clean record. You wrote him for 6 to 10 over. Your name, Trooper?
Good morning, Your Honor. Daniel McLaughlin.
All right, so what do you want to do on this one?
I will offer Mr. Ellis the same as I did with the other
You want to plead the 5 over? It's 0.
Yes.
0 points. It will go on your record. To that charge, responsible or not responsible?
Responsible.
All right, I'll accept the plea. 155 is your total cash. You enter the hall. You're all set.
Thank you, Your Honor.
Have a good day. Thanks, Trooper. I think that's it for you, right?
Yes, I do believe so, Your Honor.
Have a great day. Thank you very much.
You have a better one. Be safe. Have a happy Thanksgiving, but I'll see you before then. Same with the staff.
Thanks. You too. Emilio Alexander Coyne, 23R 723-037. All right. Is Mr. Kinney out there, Lisa?
What's the name on that one, Judge?
It's Emilio Alexander Coyne.
Oh, Coyne.
C-L-O-Y.
I see it. Mr. Kinney was out here and now I lost him. I don't know where he went.
Yeah, I'll pass this one. I'll pass that one. People against Singh Simranjeet, 25M601736.
Sorry, Your Honor, I'm a little slow today. Could we pass this one just for 3 minutes, Your Honor?
Yeah, no problem.
Thank you so much.
I'm always slow. We're getting old, right?
I'm getting old. I'm getting old, Your Honor.
Thanks. Marquise
Thank you, Your Honor.
Devon Harris, 24B146551. How you doing, sir?
Good. How are you today, Judge?
Not too bad. What's going on? You owe some money?
Yeah, I just owe some money. I just want time to pay. I put down 100 today.
You're getting right to the point. Why'd you wait so long?
Honestly, I didn't know I had a warrant, and it slipped my mind. I was going through hard times when this traffic occurrence.
All right, here's what I'll do. You pay $100 now. When can you pay the rest?
December 2nd, I come back in and pay another 100, and December 16th, I'll put down the rest of whatever I owe.
All right, I'll tell you what. You pay 100 now, 100 more by 12/2. Balance, which I'll reduce for you, to 50. So we're going to take this down to 250 instead of the 320, Lisa. That's to be paid by December 16th, you said, right?
Yeah, sorry.
Now, if you don't have the money, it's not a big problem. Just call the folk. We'll go on Zoom. I'll be glad to give you an extension, okay?
Thank you so much, Judge.
Have a good day. You're a respectful kid. What do you do for a living?
I work at United States Steel, River Range.
Okay, good. All right.
The keep going.
Have a good day. Enjoy your holidays. All right, you ready, Mr. McCandless?
Ready, Your Honor.
Didn't write anything up on this. I don't know what's going.
Well, he said he's going to dismiss in the interest of justice because the DVR says that the guy was wearing the seatbelt, but the officer claimed it was not wearing it properly. And the statute really doesn't define properly. So the DVR says he was wearing it, but according to the officer, not properly, according to the driver.
Okay. Oh, I see. He's got it in here. He did write it up. Okay.
Yeah.
So this is 25M601736, Singh Simranjeet. Your appearance?
Glenn McCandless, we have to defend it, Your Honor.
All right. Interest of justice. Prosecutor moves to dismiss. Case dismissed. You're all set. Have a good holiday, sir.
Nice to see you, Your Honor. Have a good day.
You too, always. Thanks. Emilio Alexander Coyne, if he's back. If not, I don't have anything else.
Judge, we're ready on Danielle Lumen.
I don't have a file on Newman. Did you talk to the prosecutor?
I did, Your Honor.
Mr. Mohammed?
It's an AG case. It's right on the counter.
How you doing, Mr. Kessel? Gosh, it's been a long time.
I know, Judge. I was saying to Ms. Barkovic, I apologize. I was out of the office the last time this case was called and we didn't get notice. So I checked my voicemail the next morning and it was, hey, Mr. Kessel, this is Judge McNally. And I was like, oh no.
You got a judge calling your office. Did you, who has the file, Lisa?
It should be in the courtroom.
Well, it's good to see you, Mr. Kessel, and you too, Ms. Barkovich.
You too, Your Honor.
I don't think I've seen you, Mr. Kessel, since you went over there to the Attorney General's office. I don't think so.
Judge, it may have been once. It certainly wasn't in person. So yes, it has been a long time. So, but it's good to see you too.
You enjoying it there?
Well, I've been here for 4.5, 5 years, depending on who you ask. So yeah, I can't complain.
Oh my God, it's been that long.
Oh, right. I sort of soft started right when COVID started, and then I became full-time in 21, and there were gigs.
Great. Let me call this Daniel A. Lumen, 25M117656. All right. Your appearances, please.
Yes, thank you. Good morning, Your Honor. Assistant AG Chris Kessel for the people.
And good morning, Your Honor. Camilla Barkovic appearing on behalf of Miss Lumen. Judge, I believe Miss Lumen is still in the waiting room.
Okay, we'll bring her out. Good morning, Ms. Lumen. If you can hear me, there you go. How are you? Tell me your name, please.
Good morning, Judge. Danielle Lumen.
All right. What are we doing on this?
Your Honor, Mr. Kessel and I have had an opportunity to discuss this case. Him and I need additional time to exchange information and engage in further negotiations. So what I'm requesting the court consider doing is adjourning the probable cause conference in this matter.
Let's set two different dates, and it does not have to be a Tuesday. You guys can pretty much pick your date. So why don't let's take a date for a preliminary exam first. Can you do that, Lisa? Am I good on the 1st or the 3rd of December?
Judge, if I can, I'm going to be in a homicide exam on both of those days, unfortunately.
Tell me when you're available. Let's try to work some dates. I'd like to have a probable cause conference another week and a half and the exam no later than 3 weeks from today. It's already a month old or 3 weeks old. So you guys tell me what you can work out. Fridays, I have juries. I can do it Monday afternoon. I can do it Wednesday afternoon. PCC, I can fit you in anytime, to tell you the truth.
And can we do it on Zoom, Judge? I think that would make it easier.
The PCC, you can, absolutely.
Yes. Thank you.
What days do you guys want to give me? How about next Tuesday morning or Monday afternoon? Is that too soon?
That is too soon. Could we do?
Then let's do today's the 18th, right? Yeah, let's do, you guys, how long's your homicide exam going, counsel, Mr. Harris?
It's going to be the 1st to the 3rd. So I was going to say maybe the 4th.
Yeah, let's do the PCC. PCC will be December 4th. What time you guys want to do it? 8:30, is that good or too early?
That's fine.
Good with you, Mr. Kessel?
That's fine, Judge. Thank you.
Okay, and now the exam. When are we going to do the exam? How about, Lisa, do I look okay on either the 8th, 9th, 10th, 11th, any day I can't do that?
No, it would just have to be the afternoon.
Yeah, so any of those days in the afternoon at 1 o'clock. You guys pick it.
Should we say the 11th to give ourselves the most time?
I would prefer the 10th just because I can't accommodate the 11th.
Sure. Done.
Thank you.
December 10th at 1. So preliminary exam will be December 10th at 1, PCC December 4th at 8:30. You can appear by Zoom on the PCC. Obviously, you have to be here in person for the exam. Anything else?
I have nothing further.
Anything else?
Thanks. Nothing else.
Ms. Lumen, I wish you well. We'll see you here later. Thank you. Good luck.
Thank you.
Thank you, Your Honor.
Thanks a lot. Good to see you.
You too.
You're all set, Ms. Lumen.
Thank you.
You're welcome. So I have coin. Ma'am, what is your name? Are you a witness, a defendant? What are you?
I'm going up tomorrow now, thanks. I'm his baby mom.
Okay. Well, I don't have anything else out there, right?
Yeah.
Lieutenant Rembes, what do you have here today, sir?
Good morning, Your Honor. I have a PCC for Daniel Burton. Not sure if the court already called it or not.
I have not yet.
He's in custody, so we're just waiting for his turn with the jail.
Okay, so as soon as he comes in, we'll try to take care of that for you, okay?
No problem, Judge.
Okay. I had you two here before a long time ago.
Yeah.
7 times.
Thank you for counting.
Good
Okay.
morning, Judge.
Good morning. And then there was a general civil case which was filed, and that now has been assigned to me. Judge Barr had it for the purposes of judicial efficiency. So that's where we are. Where are we with these cases? Anybody can go ahead. Go ahead, sir.
I have filed a request for default entry on it, and she has asked to open up a previous case that I filed an objection to.
You objected to the opening of the 2024 case, right?
Pardon me?
You objected to the opening
of
the 2024 case.
Yeah.
Okay. All right. So I'm just trying to get my files right here. I think your claim, sir, which is in the case. Maybe I gotta.
You want me to give you a quick overview?
No, I'm just making sure I have the right files. I may need it in a second, but when I looked at this before, because now I have an extra file, which was the one she wanted reopened. Okay. Ms. Norman, what's going on from your position in this?
Well, it was my understanding that in October of 2024, the case was finished. Like I said, there were 7 cases, or excuse me, 7 times we came in front of you. I had a case against him. I dismissed it for the possession. It was a possession case. I had a case that showed that he had no certificate of occupancy. The house was not habitable, per the township rules. And just to get some peace and to keep, out of court one more time, we dismissed my case and I thought it was over. I had money in escrow, we split that. So I thought it was over. And now here we are again. And I did send a motion to reopen my case, if this is going to go further, so that everything kind of gets heard and finalized.
Let me ask this, sir. Well, right now I have a October 22nd, 2004, but I think that case was dismissed. There was a conditional order of dismissal that was to follow in the 2024 case. So what is your claim, sir?
My claim is for physical damages that her and her family caused to the property and lost rent.
Well, what happened to once she left, what happened to the security deposit?
Are you asking me?
Yeah.
She did not have enough money paid into to fund a security deposit. She did not have that initially when she first moved in. And she was trying to get caught up on that, but she never had enough money to fully fund a security deposit. I sent her a letter after she moved out listing images that basically she did not object to that. That was the damages, was about $7,000 physical damages to the house. But there was not a security deposit being held.
Okay, well, here's the other issue. Was there, as I'm recalling in the case, and it's all kind of coming back based upon some of the things you're saying, the house did not have a COO.
At the time, or during the course of her tenancy, I was not aware that it had expired, and you're correct. There was not that COO. After she moved out, I made the corrections, and I have a new COO, and I think.
But during the time that she was renting, you didn't have one.
That's correct.
So you're first of all claiming, I understand that you have damages and you said rent. But
and the rent,
how much are you claiming in rent?
The rent that I'm claiming is all after the C.
How much are you claiming in rent after the C? Yeah, but go ahead.
I don't need that. Let's see. Well, my total on my initial complaint and amended complaint was $29,179. And prior to that, it was the damages were 7,000 something. So whatever the difference is there. I have to do some math to get an exact number on that.
Okay, you told me at the beginning you're claiming damages and rent.
Correct.
So of what you're claiming, how much rent are you claiming?
That total.
Let's try the other way. How much damages are you claiming?
The damages were, I thought I had that separated under, the damages for the, what I'm claiming for damages was $7,138.17.
7,000 what?
$7,138.17.
And those are all damages that you say are relating to her occupancy of the premises.
That's correct.
Okay, and the rest is rent?
And so it is $22,041.36 is the total complaint. So if we subtract 7,000 from that, is whatever that comes to.
So, sir, how are you? Let me just ask you this. If, and this is in regard to the rent claims, if at the time she occupied the premises, you don't have a COO, and as such can't charge rent, theoretically, how do you then at some point begin charging her rent after she's left?
Because we had a lease that went through
But
August.
the lease is going to be void, sir, because you don't have a COO. You can't enter into a lease legally.
Well, that was a contract that we agreed to, and
Okay, you can agree to whatever you want to, but you're asking this court to basically enforce what may be an illegal lease.
I made it legal when I got the COO.
But she had already left.
She vacated at that point in time after we had our other case.
Okay. But
and I corrected the oversight that I did not have COO.
But she's no longer there.
No, she's not.
So maybe follow this. If you're not permitted legally to enter into a lease, but you sign a lease, the question for the court is whether or not that lease is void, because you can't legally do that. But what you're then attempting to do is take part of that after you've had an agreement regarding her leaving the premises. She leaves the premises, you then make your corrections, get your CEO, and now want to charge rent on a lease that was probably void from the beginning.
I guess the question is,
no, I like my question better. And that is, how do you do that?
well, was the I'd have to look at the law. Does the law say I can't charge or without the COO, I can't charge rent, or I can't?
You can't rent.
Pardon me?
Theoretically, you can't rent. You can't rent the premises.
I understand what you're saying now.
Which means, since you can't rent it, then my question to you would be, if that's the case, how can you sign a contract to rent the premises?
Well, we did that. She moved in and she damaged the property, so.
I'm just talking about the rental portion right now.
I understand what you're saying.
But then it gets even, because in the 2024 case, which I understand why she wants to reopen, the claims were basically dismissed, rent waived. There was then a split of the escrow between the two of you. So at that point, the relationship from a tenancy standpoint ended.
what was agreed to in the dismissal of that. There's a statement in that line number 6 that says the defendant may be liable for money damage for additional rent or damages to the property.
Okay. I'm not dealing with the damages right now.
Right.
I'm dealing just with the rent. If you couldn't charge rent from the beginning, how can you then decide to charge rent?
I see what you're saying. I understand your legal argument there, and
I don't make legal arguments.
Well,
I make rulings.
All right.
That everybody says.
So I see what you're saying. So maybe that's the case. I cannot charge the rent that I'm asking for this.
Okay, that got you there. So now your claim is 22,000?
No, the damages are 7,138.17.
So now that's what the fight is about.
That's correct.
Okay. So when she moved in, let's just try to get some things clarified. When she moved in, was there a rental check-in list?
There was.
Was there?
Yes.
Do you have a copy of it?
I don't know that I do have that with me today. That's in my other file from the previous case. But there is a check-in inventory list on that.
Pardon?
There is that inventory condition.
Okay, so you have the one that she filled out?
I don't believe she ever filled one out.
So where is this one coming from?
Where is, I have one that I filled out when she moved in. I have another one filled out when she moved out. I do not have that with me today.
You have one that, say that again?
Pardon me?
Say that again to me?
I have one that I filled out when she moved in. I have another one I filled out when she moved out. I gave her a copy of that original blank form. She never filled that out and sent that to me.
So there isn't an inventory checklist.
There isn't one?
So there really isn't one.
Yes, I have my copies of that document.
Okay. Prior to renting to her, did you rent to somebody else?
It had been rented previously, yeah.
Do you have their inventory checkout from the previous tenant?
I do have that also.
Okay. Did you send her a list of the damages you're claiming?
I did.
All right, Ms. Norman, what's your response to the damages?
Well, first of all, I did fill out the inventory checklist, myself and my daughters, and I did submit that to him. What was the second? I'm still back on, I did.
Oh, it's okay. You get a list of the damages that he's claiming.
No, I did not. What I received was the filing from 6/3 for the damages. He never returned any of my security deposit, so he's incorrect. And in that file, and I hate to go back, but in that file, there are money orders, several of the payments that I made to him. So I did not receive an itemized list within 30 days. The first time I'm hearing.
Did he have your forwarding address?
Yes, he did. And so did Mr. McCurgy, who was an attorney for him at the time. So they both had it. And I did receive the 6-3 filing paperwork at that forwarding address. I did not receive anything else, but apparently he filed something in December that was just
Okay, so
dismissed.
ma'am, how much are you claiming you paid in a security deposit?
$3,500.
Sir,
Yes,
do you agree that she paid 3,500 in a security deposit?
I do not agree that.
How much do you think she paid in a security deposit?
I'd have to review my records, but I think it was.
Hold on. When you sent out the sheet to her, you had to subtract out, you would claim damages, and then you had to subtract out what you had.
And I had no money in a security deposit because.
Well, hold on a moment. You just told me a little while ago that you did because she didn't pay it all.
When she moved in, she did not have enough money, all of the cash that I required for her to move in. She was short the money that would be for the security deposit. She said she was going to pay that and get caught up on that. Hindsight is always 20/20, but she never got caught up on that. So she was all.
So she's saying she paid 3,500. You're saying she didn't pay any.
She did not pay 3,500.
Different answer. She's saying she paid 3,500. You're saying for a security deposit. You're saying she paid nothing for a security deposit.
My recollection is that she did not. Again, I'd have to look at my notes and my numbers that when she moved in, the exact number that she paid.
Okay, sir, hold on. Because you told me two different things here today, at least. As we sit here right now, can you tell me whether she paid a security deposit?
I don't believe she paid a security deposit. I don't believe she paid enough money at move-in to cover.
How do we not know that?
What's that?
How do we not know that? We being figuratively, how do you not know that?
Well, because this whole episode of her tenancy was a constant battle trying to help her get caught up. I had offered her a couple different options for payment plan on that, and she kept shifting gears and paying me oddball most of the money. It was the accounting was rather convoluted.
In your lease that may be void, does it say she paid a security deposit?
The lease calls for, I believe it was 3,500.
Didn't ask that. Does the lease say she paid a security deposit? The lease should indicate that she paid a certain amount for a security deposit. It should also then indicate that you are then holding that basically in trust, and it should then list out the financial institution at which you are holding that security deposit.
That's what the lease states, that the security deposit amount was, and again, I think it's at 3,500. I don't have that lease with me. That's in my file for the other case. You know, it wasn't ready to tackle this part of it.
I don't know what that means. So you would agree, at least as we sit here right now, that the $3,500, the lease indicates she paid it and that you're holding it at a particular location.
No, I would say the lease calls for that dollar amount, but she never paid it. I gave her a receipt for the money that she did pay, but she did not pay all the money that was due at time of move-in. And I can, we'll have another preliminary examination. I can bring all that documentation in, including the.
I would give anything to be in a preliminary examination right now, but no. All right. So Norman, anything else you want to say?
All of the receipts that I paid are in the file. That in the case that I'm asking the court to reopen, I was paying Mr. Stanford $2,126 every 2 weeks. He is in.
How much was your monthly rent?
$3,300. And to get caught up on the what he was saying, I'm behind. I was paying him $2,126 every 2 weeks, and those money orders are in that file. The court has.
And so you're saying by doing that and paying this excess amount, you paid the security deposit.
That is correct. And I upon move-in, actually, I was on a travel assignment. I'm a travel nurse. I was on a travel assignment and I sent him $4,000 to hold it. So that was over the $3,300 first month's rent. And then when I got there, I paid him $1,750. So all of that information, the court has.
So you gave him $5,700 at move-in?
I believe it was $5,750.
Okay, sorry, didn't mean to leave out the 50.
Oh, no.
So, no, it's okay. So you paid, you recall that, sir?
She did make a large payment.
Okay, not what I'm asking. Do you recall her giving you $5,700?
The exact dollar amount, I'd have to check my records. But yes,
Okay.
she paid,
A sizable amount.
a sizable amount, yes.
So if she paid the 57 and rent was $3,300 a month, what did that difference represent?
I'm still dry here. My lease calls for certain things that if she pays money, that money is allocated to.
Okay, here's what I'm gonna want. No, we're gonna stop today because everybody else in here probably wants dinner and we're never gonna get there. All right, so I'm gonna adjourn this out. Ms. Norman, I want to make sure do you have a list of damages he's claiming now?
I do not.
All right. You are to supply to Ms. Norman a list of the damages you're claiming. Understood?
Understood.
I also then want an accounting from the landlord of all monies paid by Ms. Norman.
Okay.
I then want, and again, this has to come from the landlord, I want the previous tenant's inventory checklist as well as the previous tenant's inventory checkout list and the initial and concluding inventory checkouts for Ms. Norman.
Okay.
Understood?
Yes. I believe, and I can, yeah. I did an extensive amount of work to that property just before she moved in. And I can document the I give you show the work orders of all the things that we did on that property before she moved in. But I can give you those things, and I'm going to include that.
Why are you telling me that?
Well, because the
previous tenant's inventory checkout list doesn't look good.
Well, the house had been rented through Washtenaw County as a halfway house for Michigan Department of Corrections people to be basically coming out of prison. That had been rented that way for several years. There was some rough conditions of it, and we went through and replaced a whole bunch of things. Did a major,
But that would be, I guess I hear what you're saying, but that would be that should be clarified on the move-in checklist.
Yes, it is.
Okay.
Like from this Norman, right?
Yes.
And it is very clearly stated in that.
But you're saying she didn't fill it out. You're saying you filled it out. But she's saying she did fill one out.
Maybe she did. I have to check on her.
So you don't know?
Not off the top of my head. I don't think she did.
All right. You just told me that she. Okay. All right. Fine. I just want both of them, the previous tenant and hers. All right. So everybody got what they need to bring me, and I need it sent to the court. How long is it going to take you to pull all that together, sir? Because that's really
3-4 weeks.
Wow. Okay.
Whatever.
No, that's fine.
I will put together photographs and whatnot of all the things, including condition, so you can see all the information. I'll send a copy.
Well, I get that, and you can include them if you want. But right now, I got to figure out what the heck we're fighting about, or you guys are fighting about. We're not fighting anything. Oh. And what's the one after that? Got it. Okay, so if it takes you 3 or 4 weeks to get that done, and then that's going to put me mid-December, Ms. Norman would have to look at it and respond as she deems it appropriate. So what I will do then is I'm adjourning these matters to January 6, 2026, 9 a.m.
And cancel the non-jury trial on December 16th.
Oh, yeah, that's canceled. Yeah, that's
January 6th.
That is so canceled.
And at what time?
That'd be at 9 a.m. Because we got to figure out what we're fighting about.
Yeah.
Okay. What date are you going to get these to the court?
Month from now.
All right. And today's the 18th, right? All right. You get those to the court by December 19th.
Right.
All right. Anything further from either side?
Judge Simpson, will you rule on the motion to reopen my case? Part of the reason why this journey started was because the house was inhabitable and I called the township for an inspection. So all of
Go ahead.
I see your hand go up, so I stopped.
Yeah, I know. That usually means be quiet, but I realize you're on Zoom. But go ahead. I'm listening.
Okay. So that is all of that information and damages and mold and all of the things. I have photographs in that file.
I know. As you guys were talking, it's kind of like having a bad dream. It all was coming back to me.
Yeah.
So I remember the whole thing, kind of.
Yeah, I figured that you.
And so I know that exists. I don't know for the purposes for which you want to use it for that I need to necessarily reopen the case. Because I realize there is evidence in that case that you may want to use, and I don't have a problem with that. I don't really want to reopen it because there was an agreement between the parties that goodness knows I don't want unraveled because that becomes my start.
Yeah. And I get that.
So at this point, I am going to deny your request to reopen without prejudice, meaning at some point, either the court or you can raise that again and I may reopen it if that becomes an issue. Okay?
Yeah. Just one other question.
Sure.
So as far as the deposit goes and within the 30 days and me not receiving that, wasn't he past his time limit?
Okay, I can't answer that because I'm not clear on any time limit because you have to understand that I can't begin to even go through that analysis when you're telling me you paid a security deposit and he's telling me you didn't pay any.
Okay.
So I have to first figure out whether or not there's a security deposit and then what that is subject to, and then whether or not the other parts of the statute have been followed.
Okay.
Make sense?
It does.
I know. Everything I say makes sense. Thank you for saying so. All right.
Welcome.
All right. Okay, folks.
See you in January.
We'll see you in January. Have a great Thanksgiving. Happy holidays. Take care.
Thank you. Take care.
Yeah, all righty. I didn't write anything here. I'm sorry, but I'm not. Everybody else looks like it won't take as long. Mill Pond Manor versus, is it Chaming Pond? Oh no, not students. Is this a student case? Why'd that come up? I want to do these two. Because this is going to take a long time because they're going to talk in big words.
It won't take a long time.
Really?
Yes, sir.
Okay, if it does, you're on the hook.
Fair enough, Judge.
All right. State your appearance, please.
Judge James Martone appearing on behalf of the plaintiff in the matter. Actually, in the case number 254C1656, appearing on behalf of plaintiff, and in the case 254C1603, appearing on behalf of the defendant.
Gotcha. Oh boy.
Your Honor,
Here we go. You're not going to read off a piece of paper, are you?
I will not. This I
You're
cannot
not going to read off a piece of paper. You have it memorized.
Yes, I
You do?
sure do.
All right, look right at me and say it.
I
then.
will.
All right.
Good morning, Your Honor. Allison Butter and my partner, Calvin O'Connell, appearing on behalf of Mr. Fan. We're requesting permission to practice under MCR 8.120 under the supervision of David Santa Croce.
She did it. I know. Score. Anyway, permission to practice is granted.
Thank you, Your Honor.
Are you in agreement that it's not going to take long?
I do agree. Your
You do
Honor.
agree? Wow,
It's a Christmas miracle.
the two of you are agreeing. That's a start. All right, where are we?
Your Honor, if I could talk generally about both cases.
Sure.
Parties have reached a tentative settlement that will dismiss both cases.
Okay.
With respect to case number 254C1656, the summary proceedings against Mr. Fan, it will be a conditional dismissal that will require Mr. Fan to abide by certain terms and conditions. Most pertinently, abide by the terms of the lease. It will circumscribe some of his gardening efforts and lay out some additional terms and conditions that will be further identified in the conditional dismissal. If there is a violation of those dismissals, there will be an opportunity for plaintiff to submit a affidavit of noncompliance and schedule a hearing for the court to determine whether or not a judgment of possession should be entered at that time.
Okay, so it's a hearing.
Exactly. As part of that case, Your Honor, the case number 254C1603 will be dismissed as well. The parties are just, that is Mr. Fan's claim against Mr. Ridings, who's sitting to my left.
Okay. So as I understand it, just in a nutshell, there's going to be a conditional dismissal on the case ending in 1656.
That's correct, Your Honor. That is
basically he's going to abide by certain terms. There'll be language in there to those. As part of that conditional dismissal and the maintenance of his, or the continuation of his tenancy, the other matter is going to be dismissed.
That's correct.
Is that how that's working?
Yes.
Okay.
We're asking, Judge, the terms are pretty much hammered out, but we're asking for a two-week adjournment to December 5th for us to submit those dismissals.
Okay. Are you guys confident that you're going to be able to get the length and everything? Why are you looking at him? Don't look at Santa Croce because he will throw like sand in the ears. Don't do that. Do you feel confident that you can get it?
Yes, Your Honor.
All right. Then I can do it one of two ways. I can give you a new date so that it's on there, or I can just mark it conditional order dismissal, order to follow in 14 days. Which way would you guys want it?
Could you just give us a date for my calendar purposes? If I don't have it, I start messing things up.
Is that what you would have said?
Exactly what I would have said, Your Honor.
Seriously?
You know, maybe not exactly, but
Really? That's what you would have said? Why are you agreeing with him?
you know, I mean, we have a tentative
Santa Croce tell you should come in here and start just fighting with him.
next time. I apologize.
Just on principle.
Okay, good.
Okay.
Duly noted.
You know that? Okay. All right. Where are you from originally again?
New York.
That's why.
Oh,
All right. So I don't know. Why did I take a shot at New York?
fair.
Yeah, it is. Yeah.
I get it.
The only thing worse is you could have been from New Jersey. All right. So I don't know why I didn't take a shot at New Jersey either. What's my next date?
December 2nd or December 9th.
2nd or the 9th? Which would you prefer?
The 9th would probably be better for me.
You can look at your calendar. She has nothing to do. She's a student.
Actually, Judge, the 9th works. I have a jury trial starting on the 10th, so the 9th will be perfect.
Will that work for you?
Yes.
Or are you guys going to like go on vacation or finals or
no.
anything?
No such thing as vacation. Always working. So no.
Yeah.
Well, that's true.
It's not true. I've been to that law school.
Yeah.
Yeah, all kinds of time. All right. December 9th, 9 a.m.
Shouldn't be necessary, Your Honor, but thank you.
Okay.
For providing.
If for whatever reason you need to appear, we'll be here.
Thank you, Judge.
All right. Thank you. Senator Croce, always a pleasure, sir. Yeah. You don't have to tell everybody. I'm busy chatting. Sue Morris versus Patrick Myers. I did not. I don't know. No, I did. I checked, but I didn't write the other stuff.
Are going, Your Honor.
Take care, sir.
Good morning, Your Honor. Ryan Sweeney, appearing on behalf of Sue Meyer. Sue Morris, I'm sorry. Jesus.
Good morning, Your Honor. Jeffrey Warren on behalf of the defendant, Patrick Morris Myers.
All right, and you guys are resolved by stipulated order for conditional dismissal?
Correct, Your Honor.
All right. I would be more than happy to sign off. However, I don't have signatures from you guys. So read over the terms. They look good. You're both represented by counsel. And so
yeah, of course.
oh, you don't even have a pen? Wow, man. No, I'm kidding.
I wasn't ready for a second.
No, it's okay, guys. All right. Thank you, folks, for working it out. And I will sign off and I will mark the file as conditionally dismissed. All right, thank you.
Great day, Your Honor.
You do the same. I did do that one. Somebody stamped my files all the 17.
I just noticed that on the.
Yeah, so yes, that probably was you. No, I know. Don't mess up. Tell everybody it was Alan. Arbor Woods versus Kiera Morris.
Morning, Your Honor. Casey Matson, P87729 on behalf of plaintiff.
Morning.
And Your Honor, I do have my client here as well today.
Your client is here. Where? Oh, right there. Okay, I'm sorry. Hello. All right, where are we? She did not check in.
She did not check in yesterday afternoon. She filed a request to appear via Zoom. She filed it with a close 3:15.
And it was denied.
Yes, because she is out of state.
But she doesn't, what do you mean that she's out of state?
She's currently working out of state.
Council hasn't seen this.
No.
Your Honor,
Yes.
if I may, we did not get a motion from her. We did let her know that she needed to be in person this morning, yesterday, around 3:00. And additionally, she did stipulate to adjourn the matter to this date and time originally.
Right. Well, just so that you see this, Ms. Matson, this is what she sent a Zoom request in saying that she's working in Vegas.
Your Honor, we would object to that.
We denied it. So I note your objection, but we denied it because, again, you're right. She had agreed to this date. And if you'd like to take a default, raise your right hand.
Yes, Your Honor.
Solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God.
Yes, Your Honor.
Go ahead. What is your?
Your Honor, we do request entry of a default possession only judgment. Rent to retain is $1,385.06. Court costs of $186.00 for a total of $1,571.06 with a writ to issue after 10 days. Your Honor, I do believe there is also escrow held by the court. We would ask for that escrow to be released.
Judgment to the plaintiff, that is by default for possession. Redemption amount is in the amount requested with the writ to issue in 10 days. I will release to the plaintiff $775, which is the escrow.
Thank you, Your Honor.
I'm just gonna, so that our clerk catch it, I'm just gonna put under the paragraph 10 that escrow, release escrow to plaintiff. Hopefully somebody catches it and gets that out. All right, that's all set.
Thank you, Your Honor.
Should have started with you guys. All right, sorry about the wait. And again, a pleasure seeing you, Ms. Manson.
Thank you, Your Honor.
Peninsula Place versus Lauren Darby.
Good morning, Your Honor. First, like a very hearing for plaintiff. Your Honor, Ms. Darby is not present. I did have to call her yesterday, and today it's going straight to voicemail. I would just request, I'm just going to submit the conditional order of dismissal under the 7-day rule.
Okay.
And we already put the briefs on the record, so it should be.
Yes, we did. All right, then what I'll do is I will indicate that this case is conditionally dismissed, order to follow. And will indicate for purposes that the defendant failed to appear at this proceeding. But all right, thank you. Sorry about the wait. You too.
These are together.
Why is it? Laurie Anderson versus Emrani Line. Hold on, Ian.
Good morning. My name is Edward Mall, MAHL P27115, appearing on behalf of plaintiff in case that ends in 3911.
Your name? Thank you. All right. So where are we on this case? 8.
This is second hearing on the case that ends 3911.
I'm taking it down here.
Right, but we've got a problem because there's this other case. Do you know about that one, counsel?
Yes, I've learned about that case. Our thought it had been dismissed and Ms. Anderson does not wish to proceed on that case at this point.
That who?
Ms. Anderson does not wish to proceed on that case at this point.
Okay, but the defendant in that case didn't consent to the dismissal and the court did not dismiss it.
Well, we're moving that. Go ahead.
Question, was there a counterclaim? I don't know about it.
She's moving to dismiss that case at this point. That case involved damages and violations of the lease other than rent. This case the second case involves purely unpaid rent. So she's asking to.
Which is the same as the other claims that were brought up in that case.
The other one was mainly for fraud. And I never got a counterclaim, so I.
Clearly, throughout the entire proceedings, she filed effectively what have been counterclaims and defenses to the actions and claims against you in the first matter.
What did I
am not dismissing the case. I made that clear the last time. I went through it with the parties. So to the extent, counsel, there is a motion to dismiss that case, it is denied.
We wish to proceed with the proofs as to the rent.
Here's the problem, and I explained this to Ms. Anderson the last time. Why would I permit a judgment in this case when rent has been paid and was part of the other case I just now didn't dismiss? Why would I do that?
There's rent that's due that is not paid. So that's why the second case was filed. And there's unpaid water bills and there were other costs involved.
3 months rent, water bill, court costs.
All of that was being handled in the other matter. So, as I was here the last time, I don't understand why I have this new case.
It was for the unpaid rent because she hasn't paid September, October, or November.
Ordered escrow, what did you think was going to happen?
She hasn't paid it.
I said, are you claiming that in the last case, there was no claim for rent?
The last case was for fraud.
Are you claiming that there was no claim for rent?
Yeah, there's claim for rent and.
Exactly. That case is still pending, which means the rental claims, which will go month to month, are still pending. And now I get a new case,
I thought you were gonna.
which just doesn't make any sense to me. At the last hearing, I told you it did not make any sense to me as to why it was filed. None whatsoever. And if you think what I'm going to do is take a new case, rule on that while the other case is pending, not going to happen. The other thing is, there's a problem violation of the court rules because she has to give, and I don't think she did. Well, maybe she did. For whatever reason, I don't even know why one would do this. Is that 7-6? The other one ending in 2176. This one.
Yes.
All right.
And I believe that white file, that's part of it. So 2 months.
So I don't understand why I have two cases.
Well, then let's proceed as the court wishes to proceed. Your Honor, you entered an escrow order in this case, was it?
Yes.
And I wish to advise you that.
In which case?
The first case.
The first case. Okay.
I did.
It's not been paid for months of October.
What do we have as a escrow? Do we know?
3 months have been missed. So have not been paid.
Ms. Lyman?
Yes, I haven't paid the 3 months, but I have the 2267 going on this week in October, November. It will be in by the end of this month.
By when?
By the end of this month.
My client just checked with the court clerk today, and there's only $6,600. That's 2 months' rent.
I just said I will be paying the 2267 this week.
All right. Because it's an escrow order, the only thing that happens is I set it for an immediate trial if there's non-compliance. We were at the point of getting a decision on the case. Are the parties going to be ready to try this in a couple weeks? Because I'm not trying it today.
Yes, we can be
Because
ready.
these pleadings are all out of order.
We can be ready to try it in a couple of weeks, yes.
Would you be ready?
Yes.
And you say you're going to have escrow cleared up by the end of this month?
Yes, sir.
2nd and 9th.
Yes.
Non-jury trial will be set December 9th, 2025, 9 a.m. on both cases. Why I'm ruling on the other one, I don't know. All right, thank you. Court does call the case of Lakestone Apartments versus Chartavia Michelle. Hello. Before you sit down, you can sit down if you want. You're gonna stand? Yeah. All right, it's up to you. Who are those little people?
My sons.
Grandsons for me.
I didn't care about you, did I? Did I ask about you? I just, you notice how he did that? Just stepped on into the conversation? My sons. Hello. How are you two doing? You sure? Are you bored? Yeah? Wow. You didn't have to be so honest. Right. I don't have anybody from the plaintiffs here.
Okay.
So I don't know where everything is, but I set this for final settlement conference today. They're not here. You have a motion for me?
I request that they dismiss this, that this be dismissed.
That's a motion. Motion's granted, case dismissed.
Thank you, sir.
You're welcome. You guys take care.
Thank you.
Sorry about the wait.
Okay, it was good. Thank you.
Was I really boring you? No, okay, all right, thanks. I feel better now. What?
Yeah.
The other, you said yes? He said, yes, I'm on my way out. I'm not talking to you, Judge. All right, bye. Bless his heart. All right, take care. The other one's gone. He was bored. 14A stands in recess. Initial and
Okay, thank you, ma'am. Huh?
Never mind. Wrong belt.
Okay, there is a Brandon also, yeah.
But he's not.
And they're both
Right
today.
there's Jeff.
Mr. Smith, is Mr. Smith here?
Alfino's taking Mr. Smith's spot.
Good morning, sir. Are you Judson Bell?
Yes, ma'am.
And this is 25 DCCR 0108, 0109, and 0110. Mr. Bell's cases are set for trial to begin with jury selection on December the 1st. And what is the announcement?
Ready, yeah.
Has there been any change? It looks like that last plea bargain rejection was from May. And any change in negotiation or offers?
What was the offer back then? It's currently 20 on the table. I'm not sure what the offer was back then.
It's coming. Hold on.
It was 20, Judge, and I assume it will be Mr. Smith.
This shows 25 for habitual, and so was there something different?
I think we went down to 20.
There was a 20-year offer
Yeah.
that was previously rejected to proceed on non-habitual.
Okay.
So the trial will proceed on habitual and 4A.
So I want to make sure you understand, Mr. Bell, that the offer that the state has given is to go on, I guess probably count 1 and 2 instead of all of the counts that would make it a habitual offender for a 20-year term in prison. You have every right, again, not to take that and go to trial in a couple of weeks, but I do want to make sure you understand that after today, I will not accept that plea agreement. If you're found guilty and if those prior convictions are true, it means that your habitual status and the minimum punishment would be 25 years. Do you understand? All right, and you want to go forward with trial? All right, we'll get the cases numbered after docket and let you guys know as soon as docket's over. You can go back with the bailiff. Bless you. Yes, sir. Mr. Burbank, on Brandon Bell?
We'll just have a second.
Sure.
On my, two of those.
Okay, on Williams as well?
Yes.
Ms. Perazo, on Traven Alexander? Sure, yes, ma'am. Well, okay. Mr. Parker, are you ready on Jamarian Martin? It's a sentencing. Jamarian Martin. Okay.
The PSI's running huge now. PSI? PSI.
See, I haven't seen this whole packet. I just saw this, I guess. Not that it matters. It's all that's what they need.
And they're all underlined now. I don't know if you've noticed that.
What do you mean?
Like every sentence is underlined. They would like that yesterday. I don't know if yours is or not. But
Mine's not been like that at all.
Two dozen.
Well, they emailed me last week and then they got in touch with these. And so it's.
That's weird looking. I don't know why. Okay, are you Jamarian Martin? And Mr. Martin was previously in court and caused number 25 DCCR 0196, entered a plea of guilty to burglary of a building. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
I have, Your Honor.
Any additions or corrections?
No worries, yeah.
Only that the state would request $500 in restitution, Judge. I think my conversation with the PSI author in this case, Ms. Banks, was subsequent to her already sending it to the court. So we were able to determine it's $500 in restitution.
Okay.
And I would also ask if the court is inclined to follow it, that it be with a condition of ISF at the very least.
So that's, yes. So my biggest question is, with regard to ISF, it's either substance or cognitive. And so because there's some drug issues, but there's also, he's young. And so what I'm considering is ISF cognitive and then JCDI as when he gets out. Does that seem appropriate for what we've got here?
I think so, Judge.
I think so. He came to court and tested positive last time, but
Right.
it probably would better address both with both of those programs. And then we can always follow up the state.
Yeah. Well, or, yeah.
Let's not go that route.
Okay, Mr. Martin, what I'm going to do, how old are you? 19. So my goal here today, and everyone's goal, is for you to be able to be successful. And so what's going to happen is you're going to be given some tools up front, not necessarily meant to be punishment, but meant to give you everything you need to change your life and be successful and go through this probation. So what that means, though, is if I do all of this now and then you violate later, coming back in and asking for another chance is probably not going to go very well. You understand? So I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 4 years. I am going to order $500 in restitution and that you follow all of the rules and conditions of probation. That's going to include entering and successfully completing the cognitive track of the ISF program, which is a 90-day program to help you make better decisions. And then when you get out, you're going to be ordered to enter and successfully complete the JCDI program, which is the Jefferson County Drug Intervention Program. That is an outpatient treatment program, but it's intensive and it's meant to help you get off all the drugs and things like that. So you're going to be able to be hopefully making better decisions, not using drug. And if you do all of that, this is an excellent opportunity because you're not a convicted felon. You don't have this felony conviction on your record. And if you successfully complete the probation, you will never have a felony conviction. The case will be dismissed at the end if you're successful. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, convicted of the offense, which means you would be a convicted felon and sent to the state jail prison for up to 2 years. Do you understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Good luck to you, sir. Sorry. Jesse Griffin, Mr. Parker.
Your Honor, before you get him out, I was going to ask for a reset on that. I've talked to him. He has a new offer. He wanted to tell me some things and want to go more with me. He's a homeless guy that he just asked if I could give him more time. I think it might benefit moving the case.
All right, any issues? All right, we'll just do a normal reset on, let's see. Jesse Griffin. We're going to reset. Cecilia Delaney, that's a competency. Cecilia Delaney.
She's not,
Oh, is she not?
She should be. Oh, she should? Oh, okay. Okay. Well, I didn't think they had her. I just said she wasn't, she said she was here.
Okay.
She is here. Yeah.
She's in our jail. So I'll hold, if you can see, we've got to get that competency thing done. Yes, ma'am.
You don't know that one?
What?
She's not here.
She's not here.
They're gonna work on getting her.
Thank you, ma'am. And so let's see, Khalil Harris.
Rejection, Judge. He's right here.
Khalil Harris. I don't see anything on here. Okay. Good morning. Are you Khalil Bradley Harris? And let's see. It says it's locked. There it goes. Never mind. All right, sir. In cause number 25 DCCR 1334, you're charged with the third-degree felony offense of unlawful possession of a firearm by a felon from August 10th of 2025. And what that means is if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
And I'm assuming we've got the prior offense. So with regard to enhancements for trial purposes.
They haven't enhanced it, but they could.
So
That's been a discussion.
y'all have talked about this. So is there just the one prior felony?
Yes.
And is it a regular felony?
Yes,
or?
it's a regular felony.
So I want to make sure you understand if you go to trial and you're found guilty, that because you have a prior felony conviction, it would enhance your punishment to that of a second degree felony, which means between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
And I have a plea bargain rejection here on the tablet that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a cap of 5 years, which means you would leave your punishment up to me. I couldn't give you more than 5 years. I could give you 5, I could give you less. It would depend on the information that was brought to me at a hearing. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial? I do also want to make sure you understand that after today, unless there's some new information that comes to light that your attorney or the state's attorney does not know, I will not accept this plea agreement after today. Do you understand? Okay, so we'll get it set for trial. Mr. Harris, Mr. Parker has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney to begin preparation for trial a little quicker. Is that okay with you? Well, it's up to you. Okay, well, Mr. Parker will remain on and begin preparation for trial then. All right, you can go back with the bailiff. Corey Balsamo,
Balsamo.
Corey Baltimore.
Mr. Paperwork.
Should be.
Yeah. Waiting for you, Judge.
Oh.
Good morning. We're gonna have to get them printed first real quick.
I was like, what?
No.
That wasn't hard.
Corey Baltimore.
2 years. Let's take it.
Who's Erica here on? Erica Burge. Okay. Are y'all ready on it? Okay. All right, sir, you are Corey Balsamo, or Balsamo. Will your client waive the formal reading of the motion?
Oh, Your Honor.
In clause number 20-34743, I have a motion to revoke your community supervision. Shows that you were placed on probation November 29th of 2021 for the offense of theft of service, a state jail felony. And that must have been enhanced because it was a 10-year sentence that was probated for 10 years. Is that correct? It alleges that you violated your probation. Count 1 alleges that you failed to avoid places or persons of disreputable or harmful character, and that you were admitted using methamphetamines within the Abundance Living Facility with another resident. And is that true or not true? True or not true? Count 2 alleges that you provided a urine sample August 18th of 2025 that tested positive for methamphetamine. And is that true or not true?
Your Honor, state would waive counts 3 and 4.
All right, did you enter your pleas of true to counts 1 and?
There's 5.
Oh, I'm sorry, I didn't see.
We're waiving 3 and 4.
Gotcha.
Not 5.
Thank you. Count 5 alleges that you failed to successfully complete the SafeP program. Is that true or not true?
True.
All right. Did you enter your pleas of true to counts 1, 2, and 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
I see the problem.
Okay. It's a 10 over 10.
10 over 10, and it's,
He was enhanced and it was already convicted, so we can't do state jail.
I missed that, Judge. That's my mistake.
So I have to delete this paperwork because it would have to be TDC.
2 years TDC.
Y'all go, and the paperwork's gone, we'll go back through this in a minute. All right. Let's see, Mr. Lewis on Christian Montoya Lazo.
Yes, ma'am.
Ms. Burge. Good morning, ma'am. If you'll please raise your right hand, do you swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English, so help you God?
Yes, Judge.
Thank you.
It's court. It's like an August case.
Okay.
And that's what he's being held on here is Harris County.
Yeah, he has a whole
And
one.
an ice detainer.
Good morning. Are you Christian Lazo?
Yes.
And Mr. Lazo, in cause number 25, DCCR 1423, you're charged with aggravated robbery from May 25th of 2025. And Mr. Lewis, what is the announcement?
Judge, I've talked to Mr. Lazo briefly about the case, but there are some other issues he has out of county that he has holds for here. I got the name of the
Landis, right? Yes, sir. Represented by Mr. Harden. We have Mr. View from the prosecutor's office, and we have Dr. Atkins, who is our forensic monitor. We are here today for a hearing on conditions of confinement, least restrictive treatment, alternatives. Court is in receipt of the report of Dr. O'Donnell, which is dated November the 5th and of 25. Court is in receipt of the letter from the forensic monitor, Dr. Atkins, dated November the 17th. And we have the proposed conditional release plan. Any objection to the court considering those reports for the purposes of today's hearing?
No, Your Honor.
No, Your Honor.
All right. Those reports will be admitted. Any additional evidence on behalf of the state, Mr. View?
No, Your Honor. There is statements from the victim representatives in opposition to the release. I don't know if the victim's advocate had forwarded that information to the court, but there was information. Their concerns that the family has in terms of release and their opposition to that.
Okay. I mean, I did get a general objection from the family members. I don't know that I have a document.
The last contact information I have from is from September, so I don't, if it looks like Ms. Burrell had been in contact, and that was the time at which, prior to the report from Dr. O'Donnell, and I did have updated the family about Dr. O'Donnell's report and the conditions of the conditional release plan for feedback, but I don't have any other responses from them in terms of specific concerns with the proposed conditional release plan.
Okay. Mr. Harden, any additional evidence on behalf of Mr. Landis?
At this point, no, Your Honor.
All right. Mr. View, anything from the state or on behalf of the victim?
I'm sorry, I was just updated by Ms. Burrell. I think she's watching, that they have not submitted any additional information to her, but we're generally opposed to the release based upon the information that we've provided to them.
Okay.
We have nothing additional to that, Your Honor. I know the court and Dr. Atkins and the team at GVCH have been trying to put in place a lot of conditions on this, and so, I think everyone's hopeful that we're going to have a smooth transition for Mr. Landis. Obviously, we have concerns for public safety, and I think the steps that we put in place kind of are going to gradually give Mr. Landis either the opportunities to succeed in the community or are going to expose concerns that are not going to make that a reality.
Mr. Harden?
Thank you. Your Honor, he knows he's got a long way to go. He has lived in a controlled environment since he was 19. He is scared. He's nervous. He's excited. He's everything. He wants to show the court, who's placed its extreme trust and faith in him, that you're not mistaken, that in doing so, that he not going to let anyone down. He understands that there are various things that he needs to do. He's not fully developed as far as his ability to live elsewhere, but I think the settings, and he's aware of the settings, I think that they are the exact ones that would be beneficial for him, and he knows that it's not over. He still has to continue working on developing his ability to cope, to basically from everything from riding the bus to using a phone to cooking to you name it. And so he'll be busy doing that and learning how to function on his own, or at least in a group home, because that's where he's headed. And, I think that's the exact correct place, and so does he. But he appreciates the opportunity and the work that was done to find him a place, because he knows it wasn't easy. It was above and beyond. What would you like to say?
Not your turn yet, Mr. Landis. Dr. Atkins, on behalf of the Forensic Monitor.
As Mr. View said, the team and myself have worked to come up with a plan with the intent for Mr. Landis to have the opportunity to be successful. This plan would include, once the TLSO, it's a transitional living housing agency, facility, once they open in the next few weeks, then Mr. Landis would be transferred there, where he would remain for up to 90 days. It is intended to be transitional and to help with Mr. Landis's adjustment to being out of the hospital, but it's still a structured environment where he will work on his activities of daily living, learning to cook, learning to do the things that he needs to do. If he is successful there, he would then be transitioned to the Smith House, which is a group home through NHO, and he would have a 90-day trial there. If he does well, he would be transitioned to their permanent housing. It wouldn't change where he was, but on paper, he would then be considered a permanent resident.
Mr. Landis, what do you want to tell me?
Well, I'm glad that I had an opportunity to come to court today, and I think I'm ready for the next step in my life. And I'm 54 years old. I got a little wiser as I got older. I'm making better decisions than I had in the past. I feel no threat to the community at all. I proved myself time and time again that I'm not going to let anybody down. And I really appreciate the opportunity that if you do send me there, I'm not going to be good, I'm going to be great there. And this has to be done. Whether I like it or not, this is the step I have to take to get back in the community. I have to do what they're asking me to do and not what I want to do. And I really feel confident in myself and the team that I'd be working with at this place I may be going to is going to help me be successful in the community as well and their rules and regulations there at the facility. I have toured this place where I'll be going to. It's pretty restricted. I'm excited about moving forward in my recovery, and like Jim Harden said, it's not over yet. I still have more work to do, and by going to this facility, it's going to give me the opportunity to do a lot of things I've lost, learn how to do, such as cleaning, cooking, how to ride a bus, set my own appointments, from beach to set. And the mainly thing of this whole situation I'm in is continue to take my medications. They're very important. I've changed tremendously since I've been on medicine since 2015. And there's only had one little slip up with the issue with my brother. And I totally regret what I said. I didn't mean anything by it. I just wanted to piss him off so he can just leave me alone. But that's not the way to handle things in the future. And in the future is tell the people who's there where I'm going to be placed at and let them know what was said and who called, the date and time. But, Your Honor, I really feel I'm ready for the next step in my life. It's been a long journey. That's pretty much what I got to say for today.
So, a couple of things, Mr. Landis. First of all, it's been really no secret that we've been working towards this really the better part of the year. That I wanted to get you out of Summit and into someplace else. We didn't know where that place was going to be. We tried to do the off-site visits and all that kind of stuff between problems with the facilities and mandates from the state, whatever. That didn't really seem to work. So, a lot of what you told me was correct, Mr. Landis, that I do think that, that you need the education, you need the structure, you need the opportunity. I think all of those things are correct. And I do appreciate the insight that you have onto your medications. because I remember when I inherited this case from Judge Bronson in 2013, your position with Judge Bronson was always the same. I ain't taking no medicine. And then your position with me was pretty consistent when we started. I'm not going to take the medicine. We had a couple of hearings where they wanted to force you to take the medicine, and I said no. The reason that you didn't want to take the medications is because it had some side effects that might include your death, and you didn't want to take them, so I didn't make you take them. I do think that you had it in your head that you were going to wait me out and somehow you were going to get out of the facility without taking the medications. But I do remember, Mr. Landis, when you started taking your medications voluntarily, and I remember seeing the changes in you. It was not the defiant, I'm going to do what I'm going to do, I'm going to work this angle, I'm going to see how I can get what I want. It was a much more reflective, it was much more self-aware. And, you know, we've been working up almost 10 years. We've had some setbacks, rather significant setbacks. When we had the incident when you were on the pass, that was terrible. I think you recognized that that was terrible. But I do think that medication is important, and I appreciate your insight onto the medication aspect of it. Where we're going to disagree, though, is where you tell me that you are ready for this next step. Because, Mr. Landis, you are not. You are not at all ready for this next step, and I think you are wise to be afraid. I am afraid. Mr. Harden is afraid. Everybody in this courtroom is afraid of that next step. But the reality is, Mr. Landis, the only way to find out if you can learn the things that you need to do to survive outside a hospital is to be outside of a hospital. And yes, you are still mentally ill. Yes, you still present a danger to the community. But the least restrictive treatment is no longer a hospital. The least restrictive treatment is now some sort of other setting. But we gotta teach you a bunch of stuff. And that's what the TLSO program is gonna be. That first 90 days is gonna be a lot of education for you. A lot of you getting more comfortable, learning how to do stuff, but also being more comfortable. You are not permitted to leave that facility for any reason. And if there is a reason for you to leave, like there's a medical need, that's going to come to my attention, and I'm going to sign a court order specifying the conditions under which you are to leave that facility. Otherwise, if you leave that facility for any reason, I'm going to treat that as an escape, which means you're going back to the hospital. And I don't say that to be all, you know, blah, 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 you need to know, you know, that's not, I'm not trying to scare you into compliance. I just want you to know what the consequences are of any step that you take outside that facility. I don't care if the place is on fire. You find a place inside the building that is not on fire, and you stay there until somebody comes and gets you. After that 90 days, we're gonna move to a different phase, though. We're gonna move hopefully to the Smith House, and you're gonna be on restricted movement, but you're gonna be able to leave that facility. It's gonna be approved by your treatment team, and you're gonna go places. You're gonna be on a monitor, so we're gonna know where you are and when you're out. We're going to have some people that you are not allowed to have any contact with whatsoever. Mr. View is going to get me the specific names of those people. You already know who they are, but I want them in my order so it is clear. When you have some restricted movement, you're allowed to be out in the community. There's some places that you're not going to be able to go. And your community corrections officer will tell you specifically where those areas of the community are that are off limits to you. You are not to cross into those for any reason. We're going to review this case in about 6 months. At that time, I anticipate that you're going to be out of the TLSO into the Smith House group home, and you're going to be doing well on your passes, and you're going to be gradually working your way up to a point where you can make the decisions where you're going. If I want to go to the store today, I'll go to the store today. If you want to stay home because it's raining and cold out, you have that option as well. But we're still a long way from that. I also, there was something else. The TLSO facility is not open yet. So you're not going there today, you're not going there tomorrow. But when it opens, we are going to get you over there unless it opens before December 1st. We're not set up for you to leave the facility before December 1st. I don't anticipate the building's going to be open before then anyway. But I do not want to send you over to a new facility and then be on a skeleton crew because of Thanksgiving and the holidays and all the stuff that comes with that. So we're going to get you hopefully out probably sometime in mid-December as soon as they open. I do find that you remain under the the continuing jurisdiction of the court. And until you are determined no longer to be a mentally ill person subject to court order or the expiration of your lifetime, you're under a lifetime commitment, because I do find that you continue to be a mentally ill person subject to hospitalization. But again, the least restrictive treatment plan is no longer the hospital. It is the community under the conditional release plan. Conditional release plan has been drafted, but has not yet been finalized. I know you've seen a version of it, but we need to get that into final form. Have we ever done an NCIC Form 95 on Mr. Landis? Because if not, we need to make sure that we do that. Okay. All right. Anything else, Mr. View?
No, Your Honor.
All right. If you could please provide me with the names of the people that Mr. Landis is to have no contact with. I will incorporate that into my order next week. I'm not going to get this order out until next week. And then the exclusion zones we will deal with when community corrections is involved in the case about 90 days out.
Okay. You only need the names before December.
I only need the names.
Okay.
All right. Anything else from the state?
No, Your Honor.
Anything else from the defense?
No, Your Honor, thank you.
Anything else from the forensic monitor?
No, Your Honor.
Mr. Landis, you're right to be excited about this. This is a big deal. So we've been working really hard on this. Don't let us down.
Can I say something real quick?
Sure.
I just want to be clear to make sure that I'm on the same page here. The place I would be going to is not opening right now, right?
It's not open yet, no.
And also, when I get there, I cannot leave that facility until like 90 days.
Correct.
Okay.
When you're transferred to the Smith House.
Okay.
Now, there might be, similar to where you left the hospital to go visit the place, there might be those types of departures, but that will be pursuant to an order signed by me that says that Mr. Landis, it's kind of like a furlough. Maybe you don't know what a furlough is, but it's kind of like where I will say, okay, we have an appointment for Mr. Landis to go to the doctor on such and such a date at such and such a time. He can leave the facility accompanied by his treatment team or whoever, case manager, whoever's going to go with you to that appointment. And then you're going to come back. If they decide that they want to take a trip to someplace where it's therapeutic for you, I'm not necessarily going to be opposed to that as long as it's in a supervised setting. But unless there's an order by me, you are not to leave that facility.
Okay. Thank you, Your Honor.
But I think it's a good idea that we get you out in some sorts of settings, but they're going to be tightly controlled.
Okay.
But you need to focus while the 90 days that you're in TLSO, you need to focus on learning how to live day to day. This is what I need to do when I wake up in the morning, and that gets me through the day. And I know sometimes you do get focused on this, Mr. Landis. Well, I really want to focus on the next step, which is me getting out in the community. Don't, because once you get to the Smith House, that's when we're going to start teaching you this is how you manage yourself out in the community, and we're going to gradually, very, very gradually introduce that.
All right, thank you, Your Honor. I appreciate your time.
All right, that's all.
So, Even if the doors are unlocked, you can't open it and go out and stand outside.
We don't do with the commitment, right?
Not, you know.
You don't need the paperwork for a commitment. You
attorney over there. I was trying to see if we can get something worked out that would encompass both of them. I was under the impression he was setting trial on a robbery over there, but evidently it's something different.
Okay.
But I will check into that and make sure we get to take it.
Judge, according to his jail screen, he has holds from Harris County for a burglary charge and a theft charge. I looked on the Harris County District Clerk page. It only shows that burglary is pending at the moment, and it wasn't set for trial. It was just essentially a new case that he was not able to appear for because he's here. His offer is 25 years on this case, I would imagine. If it's a burglary pending in Harris County, it's going to be lesser.
We'll take care of it first.
Yeah, and I think, Judge, honestly, in not being on the trial docket over there would make it a little bit easier for me to give this attorney over there and get something worked out that will take care of both sides of it.
Okay.
I mean, of course, he still has to deal with the ICE issue.
Okay. So I'm just doing normal reset. That'll give you time to visit with the Harris County Attorney and Mr. Nichols, and then go out and visit with Mr. Lazo. And we'll see if we can get an announcement at the next court date.
Sure, Judge.
Thank you, Your Honor.
Thank you, Ms. Bursch. Denzel Spikes, Mr. Lewis.
Judge, hold on, I know Mr. Hopper was looking at that one.
Okay, I'll hold it. Robert Eaglin,
Yes,
it's a
Judge.
bond hearing.
Robert Eaglin.
All right, sir, you are Robert Eaglin? And give me just a second. Mr. Eaglin is charged with aggravated assault on a family member with a deadly weapon, and Mr. Lewis has filed a motion asking that his bond be reduced. The bond is currently, let's see,
It was 150.
what is it set at now? Do y'all know?
I think 150.
150. And it looks like there was we were set for trial, and there was the state requested a continuance, and so Mr. Lewis has filed this motion to reduce bond. Ms. Malfino, what is the state's position?
Yes, Judge, the state did file a formal written motion to bring it before the court. I certainly understand that Mr. Eaglin via Mr. Lewis certainly entitled to ask for bond reduction based upon that announcement. Where I am is that the complainant in this case, if the court will recall, it was originally handled in CDC. She was unable to be located. So although the often stated in the indictment looks old, he has not been in custody for that length of time. So I'd like you to take that into consideration. She has recently had a stroke. She is still in recovery for that medical condition. I spoke with her on the phone. She's always been very attentive in reaching out to us. It's difficult. Her mobility is severely limited. Her speech is still limited based on that stroke. And for that reason, I would ask the court to consider allowing for a continuance off of that December 8th docket, and so that we could know in advance so she doesn't have to leave her rehab facility. And I've discussed that with Mr. Lewis, who's always been very courteous about it. I understand the necessity for him to ask for a bond.
Sure. Mr. Lewis?
And Judge, that parceless cut, that involves, of course, the length of time that he did sit in custody while he was in this case was pending over in CDC. And I think he was a very lengthy time, almost 3 years is what he was in custody for before that case was dismissed, because they could not locate her. Shortly after that, of course, he was refiled. He's been in custody all of this time. We were ready to go to trial because the stroke happened right before the last trial setting. And I think, we discussed it at that point, which I was gonna, and this was the first update we've gotten, that she's still dealing with the rehab and everything.
Okay. So,
And typically, Judge would know not to ask more than once. It's just a very severe medical condition.
sure,
and
yeah,
very
no, I'm
serious
going to grant the
aggravating
motion for continuance, but in turn, I think I'm required under
Yes.
17151 to do something with regard to the bond. So I want to get some specific information from you, Mr. Eaglin, so that I know conditions to place on that bond. Where will you live if you make bond?
With my mother,
What is her name?
Marvel,
Marva
Eaglin,
Eaglin, okay, and what is that address?
3705 East Lucas Drive.
So that's here in Beaumont,
Yes.
okay. As far as you know, Ms. Molfino, obviously there will be some restrictions and no contacts. Was there any issue that you know of when Mr. Eaglin was out from the time that case was dismissed until the case was refiled with any type of contact or threats or communication with the complaining witness?
Not that I'm personally aware of, Judge. I certainly would be happy to talk to Mr. Laird about it. I know that the complainant at the present time is very concerned for her safety, just based upon the aggravated nature of the offense, and I don't feel like it's necessary to show the court the pictures of that, but I think you would probably.
I'm looking at the
agree.
probable cause, so it's an allegation of being stabbed multiple times?
Her throat was slit, yeah.
Okay.
Again, I certainly understand the bond requirement and would ask that in the event he does postpone, that he have to wear a GPS at all times so that we can monitor his whereabouts. I know the complainant's whereabouts. I would like him not to know that. And also for him to remain in Jefferson County, specifically in Belmont. He also has a prior felony conviction.
I'm sorry?
He also has a prior felony conviction.
Okay. All right, so here's what I'm going to do, based on the, my granting that motion for continuance. I am going to grant the motion under 17.151 to reduce the bond as well in Mr. Eaglin's case. I'm going to reduce your bond to $25,000 in your case. There are going to be several conditions that are extremely important. The first is that you will be required to wear a GPS monitoring device at all times. You will be on house arrest except for employment with my permission. So if you have opportunities to get employment, you need to get with Mr. Lewis. He'll let me know. All it takes is an email and I can approve or not, things like that. Also, obviously you can come to court and you can visit with your attorney, medical doctors, things like that. But other than that, you are to be on house arrest at 3705 East Lucas here in Beaumont. You're not to leave Beaumont. You are going to be restricted to live and work in Beaumont, Texas. Do you understand those restrictions?
Oh, I can speak now. I'm trying to change venue, motion to change venue because this case is prejudice and it's been dismissed and it's been brought up 20 days later while I was out there helping my dying mother. I didn't do it the first time.
Okay, so here's the thing. You got a lawyer, a motion to change. All right, you're not
I
getting.
wrote the state bar about it and I'm.
Your motion to change, all right, listen, your motion, listen, don't talk over me, okay? Because I can change my mind real quick on what I just did.
I'm not even trying to bond out, ma'am. I'm trying to get out of the county with this case so that this case can get.
That's denied. Your case is going to be here in this court with me, okay?
Yeah, I understand.
So.
But I don't need a bond though.
Then I'm going to withdraw everything that I just said. I'm going to deny the motion for bond reduction. And so what we'll do is just reset the case on the next available trial docket and we'll move forward with trial. Go back with the bailiff.
And Judge, that's what I was going to say. I'll get evaluated.
Okay.
Because At the last time I saw him, we were fine.
Okay.
Then all of a sudden, he stopped wanting to visit with me.
Okay,
So-
just send something over and we'll get it taken care of. I know. Okay. If you don't want to do it. I made all kinds of good notes here. Russell Bean, Mr. Lewis.
Yes, Madam Judge. And if we can hold on that, we have
Sure.
an agreement worked out.
Okay,
But he's gonna need to go plea on the misdemeanor cases first.
okay,
I was just waiting for Mr. Cole to get here. He's his attorney.
gotcha. And then Dijon Banks.
Thanks. That one, I've talked to Ms. Malfino about. There's a lot of discovery on that one.
Okay.
And that we still need to.
So you need some more.
Yeah.
We're going to reset Dijon Banks and hold Russell Bean. It sounds like he might need to, at some point, go down the hall. I mean.
And on Banks, Judge, at some point I may ask the court for your assistance in procuring some school records of the young child in this
Okay.
case. There's some autism involved, and sometimes those are difficult to get out to the court order, but I'll be glad.
Okay, yeah, just let me know. I'll sign an order if you need it. Okay. Mr. Burbank, are you ready on Brandon Bell?
Brandon Bell.
You sure you're ready?
I did.
Yes. Okay. Is that okay if I just do it?
Yeah. Mm-hmm.
Who's in the wheelchair?
Good morning.
Good morning, you're right. I had 2 counts.
No, I think he's the only one. They're just confused on which one.
All right, I have it ready.
Good morning, sir. You're Brandon Bell? And this is cause number 24, DCCR 1008. Mr. Bell was previously in court, entered pleas of true in a motion to revoke deferred probation, pled true to counts 2, 3, 4, 6, 7, 9, and 10. And there was not an agreement on probation for aggravated assault with a deadly weapon. And I've received that updated report. Has everyone had an opportunity to review that report?
I have, Your Honor, in addition to some medical documentation that Mr. Burbank has provided.
Was that provided to me?
Not,
Okay. I'm sorry.
probably not.
Okay. What should it have?
Based on the updated report, when it goes into Spindletop and some other stuff, Judge.
Uh-huh. I don't know what you're talking about. Yeah, I mean.
These are medical records from Spindletop.
Okay.
And there's also medical records of how he lost his leg recently from being run over by a dump truck while working.
Okay.
Which I think are factors that need to be addressed.
Probably in addition, Judge, if I may, to the fact that you were called a complainant in the underlying case for which he is on probation. It looked like a stretch to even put him on the probation with his history, but she was very adamant about wanting probation or even non-prosecuting, and she came and testified before you the last time the motion was set so that you could advise them both with respect to the no contact order, which I don't think either one of them were following, but I don't have proof of that, but I know
Okay.
that's been a concern, but had some difficulty with that portion of the case.
Okay.
And if the court would also remember, she was expecting another child, they are expecting another child. And
Okay.
she's
So what,
also-
go ahead and make argument and then I'll,
She's also controlling the checking account. He's getting settlements and he's providing the money to her for the children. They still have a house together. But he does have a place to stay, Judge, and that is his mom's, which I believe she can't go to. And my argument, Judge, is, if I may, is that he has mental health problems. He's had some problems in reference to possibly smoking marijuana, but I think it's contributed to things that he has gone through in life. As I said, had some medical in reference to an amputation. Of course, he's lost part of his right leg. That was due to a dump truck backing up over him while he was working. And then you couple that with mental health issues. He was reporting, my understanding was he kind of was talking out of his head, as also reported by his mom. That was also outlined in the updated PSI report. We're asking, Judge, that you continue him on probation. He does have obligations with his significant other in reference to the newborn and making sure that they're taken care of, which he does have the funds that he has to be able to give to her. But if there is some program that he can have that's outpatient to maybe give him some direction. One last time, he was put on probation in April of this year, Judge. We're now in November, but the problems have been going on. But he does need to go back to Spindletop. He does need to say this is what you do or not. I mean, according to the pre-sentence report, he is reporting. It's not like he's not reporting. He's trying to pay or has been paying and trying to do stuff. I think he just needs a little bit of a correction and see whether or not he can do it. And you couple all that. I've had extensive conversations with his wife. I've tried to tell her the way it has to be as of yesterday. We've talked over the phone in the way that it would have to be in reference to separation until they learned how to possibly get along together. So that's what we're asking for, Your Honor.
Ms. Malvino?
Judge, would the court like to hear evidence with respect to counts 1, 5, and 8 in Ms. Lopez?
I mean, I guess it kind of depends on the.
Just in the context of what she has to say.
Yeah, for sure.
I call Ms. Lopez.
Ms. Lopez, if you'll raise your right hand, do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? All right, you may proceed.
Ms. Lopez, would you please state your full name for the record?
Rachel Lopez.
And how are you employed?
I am the high medium risk officer at adult probation here in Jefferson County.
And are you the supervising officer for Brandon Julius Bell?
Yes.
And do you see Mr. Bell to your left in the wheelchair?
Yes.
I'm going to record reflect Ms. Lopez is identified the defendant.
The record will so reflect.
As a condition of his probation that was granted by this court back in April of this year, 2025, was he given certain terms and conditions that all probationers are to follow?
Yes.
And specifically, you've had an opportunity to review the motion to revoke that was filed back in July.
Yes.
In account number 1, it alleges that he failed to immediately report to you his or her contact information in violation of condition. Can you explain that to us, please?
There were multiple instances throughout the time that he was reporting where I would attempt to call the number he had provided at a previous office visit and would not be able to reach him. So then I would have to then search through his associates to find someone else who would answer, who would then say, we'll let him know you called. And so it's standard in our court orders that offenders are supposed to keep their contact information updated due to the fact that most of the time I cannot give out certain information to other people due to confidentiality.
So it's obviously very important that you're able to reach him and advise him of the conditions of his probation center.
Yes, we need updated phone numbers, addresses, things like that, so that we can specifically talk to the defendant.
And he pled true to additional allegations, including providing some dirty UA specimens being out past curfew. Was he ordered by the court to provide all records and documentations as required by you to you as his officer?
Yes.
And did he do that?
Yes, whenever it applied in regards to like spindle top, yes, those type things. I haven't had any kind of paperwork in regards to the settlement that Mr. Burbank has referenced, but I also recognize that that may be a recent thing. And so that may not be applicable yet, but otherwise, yes.
So some things you're able to verify, but yet others you are not, which is why you felt it important to include in the motion.
Correct.
And additionally, in allegation number 8, did he admit to you the adulteration of his UA analysis on or about June 30th of 2025?
Yes, when he submitted that urine analysis that date, it was clear in the cup, and I did make a note of that in my chrono. It should be noted that even if someone is extremely hydrated, their urine is not crystal clear. And so when I specifically asked him in the offices at that date, did you do something to make it be negative? He said yes. And so while the drug test reflects negative, he admitted in the office visit that he had taken something, drank something to adulterate his urine.
And in fact, you and I have had a lengthy conversation in the past about his use or suspected use of K2 synthetic marijuana, which lends to possible negative UAs when in fact he would be positive just due to the nature of that synthetic.
Yes, Ms. Strother, our UA tech, has explained to me that K2 is a difficult drug to drug test for because much like the flu, there are multiple strands of K2 drugs out there, and our drug test can only specifically test for one type. And so if he had not used that specific type, it would test negative. And so the incident reports that I received through Beaumont PD indicated that the effects that they were seeing in their reports indicated synthetic marijuana use.
And that information is also reflected in your update to the court, correct?
Correct.
With respect to how his behavior appeared to be altered, involving odd hours, showing up at odd places, attempting to contact the complainant, et cetera, regardless of whether or not they mutually agreed to do so. And I believe your recommendation is very well thought out and very well put in the updated PSI. Do you have anything to add to the report?
I do not at this time.
You have some questions.
I have some questions.
Yes, sir.
Ma'am, did you ever get his records from Stone Tepe?
I believe so, yes.
And was he under medication?
Not during the time of all of this taking place. I know that since he was out on bond, I believe he went to Spindletop as of August 11th, and that was when he began having his medication the way he was supposed to.
In your report, you stated in the first or second paragraph that while the defendant does report as directed, he has made basic efforts towards paying his fees, correct? So he has been reported to you.
Correct.
And then you also started receiving phone calls from the victim. Did you have any dealings with the victim at all? Were you here the last court hearing?
I was.
She didn't act very rational either, did she?
Not often, no.
And do you realize that they are expecting another child?
Yes.
And how many other children do you remember?
I believe they currently have 3 children together. I believe this is the 4th.
If I told you that there was a settlement to Scott Brown in reference to the motor vehicle accident that took his life, you wouldn't disagree with that?
He told me that at the jail when I did my PSI update.
And he's getting monthly, I guess, settlement checks or quarterly settlement checks, in which the wife does have access to his account.
That I don't have any knowledge of.
You did also receive telephone calls from his mom, correct?
Correct.
And basically, she said that he's talking out of his head. He has mental health issues, right?
She did at one time, yes.
She didn't know, well, has to be between April and now, right?
Yes.
Because it was put on.
Specifically whenever he was out on bond.
Okay. He did appear or direct to be kind of delusional state, correct?
Yes.
Unable to remember, reference to taking medications or injecting, so he was on some type of medication, correct?
Correct.
And that one of his problems is that he has to learn how to remain on his medications in order, from spindle top, in order to, I guess, try to live life normally, correct?
Correct.
Nothing further.
Anything else, Ms. Malfino? I don't know yet what I'm going to do, but is there any reason based on the injury that Mr. Bell could not go to special needs safety? Is that something that would prevent him from going?
I do not believe so.
You don't think so? You don't think so?
I think there are people that have gone to spindle top that are
Sure.
in wheelchairs and things of that nature.
Yeah.
I said spindle top, I'm sorry, safety.
Yeah,
So I think he would still be able to go. I think it would be under special needs.
right, that's what I would,
Yeah.
if that were an option, it would be special needs because that would address both
That
of the.
addresses mental health also, Judge.
Yeah, that's what it's for. I mean, and here's the thing. I think a lot of the mental health is because you're using synthetic marijuana. I mean, that's gonna, so. Ms. Malfino, anything else?
Judge, I think you have a lot of information before you had to enter your decision. I do think it important, and I didn't want to hide behind the fact that we have had the issues with the complainant that she did come and testify.
And that's the only thing that's keeping me from doing probably what needs to happen.
But I don't have an interim update with respect to her.
Have you heard anything?
I have not heard anything since all of this happened. The reality is she's called me multiple times and complained and said that Brandon's here and she wants him gone. But Ms. Lopez, please don't send him to jail. She is very back and forth about it. My largest concern, Your Honor, is that the offense that the defendant is on probation for is extreme. And my biggest issue in truth is the fact that Mr. Bell does not take any responsibility for any of it at all.
I don't disagree.
Can I just have one question, Judge? Did this accident happen after
When did your accident happen?
November 4th of last year? Of last year.
So all this has happened since he's been on probation.
Was this
Prior.
before, was that prior?
His
to
accident
his
was
accident?
prior to when he was placed on probation.
Right.
No, but how about the incident itself?
Oh, the underlying offense?
Yeah.
April of last year. So the underlying offense was prior
Prior to
the injury. But the injury was prior to probation where he's still, I mean, regardless of you can still do things to injure someone, to harass someone, to put someone in fear with or without a leg. And that's what he's done. That's what you've done. Still make babies with her. I mean, I don't know. I mean, that she was pregnant. The whole point of this is you beat the crap out of her when she was pregnant, and now
Third child.
And now we've got the fourth.
Correct.
Judge, would you like me to do a witness call for her and see if for some reason she showed up today?
Sure.
Or needs to speak with her, Adriana Bell?
Can we do a call for,
Adriana Bell?
I don't know if that's gonna help either, though. We've done that before.
And I don't know if it's a situation where it's the court needs to protect somebody from himself.
Do you want to reset it so I can possibly?
I don't think it's gonna matter. I mean, she's been here before. I've ordered.
No response,
I think I have her mother's here.
But there was a no contact, and now we have another baby. So obviously there was contact.
Can I address that? From what I found out, Judge?
I don't need Snickers from the gallery.
I'm not calling them as witnesses. Every time they got mad at each other is when she got on the phone.
But she got on the phone, but that's him blaming. He beat her. You admitted to beating her. So she's probably scared when he gets mad. And then it gets okay, and then it gets mad. And he doesn't know how to get mad without beating the crap out of her.
I didn't get that indication, Judge. She's been to my office every other day. She's called. I mean, it's really,
I'm not in disagreement that Ms. Bell is also the problem, but my biggest concern here is their children.
separation.
Yeah.
I don't care if they stay together or not, admittedly, frankly.
Yeah.
I'm more concerned about the children involved in this case because of the violence that they're being subjected to. Whether or not the two of these adults can reconcile is between them, but there are children involved that I am extremely concerned about.
I agree. All right, here's what I'm gonna do. Mr. Bell, I don't feel like I have any other choice at this point but to protect your children and to protect your, I don't know if y'all are married, girlfriend, wife, mother of your children from you. I understand the mental health issues. From what I can tell, most of those are self-induced because you were using K2.
There haven't been an incident since I've been on probation.
That's not true.
I haven't had no abuse cases. I've been on probation.
Okay, so you haven't abused her, but you weren't even supposed to be around her. I gave you don't talk over me, because y'all I told you when I put you on probation that she cannot give you permission to violate my order.
Yes, ma'am.
She can't say, it's okay, come on over.
She came to my house. I was staying in the house. She wasn't staying there.
Lock the door, kick her out. You're the one that's gonna go to prison.
She said that she called the laws to kick me out, and you said it still was an issue. She called the laws to kick me out. My mama came and got me, and I've been staying with my mama. I ain't been around her. She been calling the laws on me every time she come to my house. I paid $100,000 cash.
Why are you still having sex with her and having babies?
That's early on.
Early on when? We've only been doing this for 6 months. You've had 6 months and all this has happened in 6 months on probation.
It happened 3 months because she finna have a baby next week. 3 months before I was on probation.
So what if she shows up at your mom's house?
She's not gonna show up over there. She know her and my mama don't get along.
Probably for good reason.
I would represent to the court that there is a problem there, Judge, because even when we talked about possibly with him seeing the kids without her at mom's, and that wasn't a possibility. There's something between her and the mom, his mom. And I know his mom, his brother has gotten in trouble. She has a very stable job at a bank. She's very straight-laced. His brother was the one in the West End that was burglarizing cars, and the owner stopped him and shot him about 8 times on the road and left him there. But she is very straight-laced, and she just couldn't get off of work this morning because of the bank.
So.
But he needs something, Judge.
Well, but we tried to give it to him.
Well, I'm talking about.
I have money now to pay for my battery class too. I have money to pay for my battery class and pay off my probation.
I'm not as worried about you paying off things as I am you having continued contact with her.
I'm not gonna be in contact with her anymore.
Is there a way, Judge, to put him on a GPS and reset this for 60 days?
No, I'm going to make my decision today because I'm absolutely, if I leave him on probation, he's going to safety, period. So we're not going to get out and see how we do and take that chance without having some kind of treatment up front. I don't know. Y'all hold on a second. Just don't take them far. For some reason, Anna, when I pull up the version that should have my notes on it, it doesn't have anything on it. So I don't know if I didn't save it. I have the prior version and the new version. I printed out that new version and it doesn't have it. The date and all that. So I might need to go back and handwrite something from that date, but just remind me I put a sticky on this. Okay, let's see. Ms. Holmes on Samuel Harmon.
Samuel Harmon. So, side note on him. His dad called me and said he filed a grievance on me, but I'm still gonna represent him. But he apologized for filing it because he said he didn't know I was coming to visit him that day. Yeah. Okay, I'll follow.
The joys of what you do.
Yeah.
Good morning. Are you Samuel Harmon?
Yes, ma'am.
And this is 25 DCCR 1019. Mr. Harmon's charged with aggravated assault with a deadly weapon. And Ms. Holmes, what is the announcement?
Yes, Sharon, if we could get one more reset. We did receive another offer from the state today that I would like Mr. Harmon to review with his family. And also I'll come out to visit with him as well so we can make a decision by the next
All right.
court day.
I'll reset one more time. Any issues?
Just, Your Honor, that was a 12-year offer that's going to remain open until the next court setting.
Okay.
Withdrawn.
Okay, so Mr. Harmon, it sounds like there's an offer that's on the table that they've going to keep open until that next court date. Make sure you visit with Ms. Holmes about it, visit with your family about it. Sounds like there's not any more negotiation. The offer is what it is. If you want to take it, we'll take care of that when you come back. If you don't, you want to trial, we'll get your case set for trial. Okay, you can go back with the bailiff.
Thank you, Your Honor.
Brittany Litchfield,
Yes.
would y'all, I'll print the first one if you'll print the second one, please. Is Burbank still in here?
Yes.
Mr. Burbank, do you have somewhere else to be?
No.
Okay, I'm just gonna give me just a minute to
Yeah,
do.
I was supposed to be in hard guy. I'm not going back.
Okay.
Take all that.
Okay, thank you. Good morning, are you Brittany Litchfield? Give me just a second to get this printed out. And will your client waive the formal reading of the motion in each case?
Yes, Your Honor.
Ms. Litchfield, in cause number 21-37098, I have a motion to revoke your community supervision. Shows that you were placed on probation December 12th of 2022 for the state jail felony offense of abandoning a child, and that was a 2-year term in the state jail prison that was probated for 5 years. Is that correct?
Judge, we'll instead of amending, I guess it's 6 and 7 on each motion and just proceed on 1 through 5.
In each motion, 1 through 5?
Yes, ma'am.
It's okay. All right, and then in cause number 21-37099, I also have a motion to revoke your community supervision. Shows you were again placed on probation December 12th of 2022 for the offense of abandoning a child, and that was also a 2-year term in state jail prison that was probated for 5 years. Is that also correct? Each of these cases, the state has elected to proceed on counts 1 through 5 in the motions. They each allege in count 1 that you violated your probation by failing to report to the probation department as directed October 15th, October 31st, and November 14th of 2024. And is that true or not true? Count 2 in each case alleges that you failed to work faithfully at suitable employment and provide verification of that. Is that true or not true? Count 3 in each case alleges that you failed to immediately report to the probation officer your current address. Is that true or not true? Count 4 alleges that you failed to provide verification of performing the community service hours that were required. Is that true or not true? And then count 5 alleges that you failed to provide verification of entering and successfully completing the parenting class. And is that true or not true? Did you enter your pleas of true to counts 1 through 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts in each case because they're actually true? In each of your cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreements that you've reached with the district attorney, that you will be waiving or giving up any right to appeal? State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Ms. Litchfield is not competent?
No, Your Honor.
All right, ma'am, in each of your cases, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence in each case to revoke your probation. In cause number 21-37098, revoke your probation and reassess your punishment in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 25-37099, also find sufficient evidence to revoke your probation, and at this time revoke your probation, reassess your punishment in accordance with that agreement to a term of 12 months in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm going to hand you in each case the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. Good luck to you, ma'am, and thank you for being here.
On bail, there is one in there
There
that
is.
says revised, yes. You must have not saved it, or.
I must have
didn't
not.
save it, and then I must have printed and
Got
gave
it.
it to you.
Okay.
So there is, do you need it?
I can, yeah. Yes. Maya Sparks, Ms. Holmes.
I'm not gonna say yes to yeah, just for the mental storage, I don't know. Sorry.
Do you think we'll get a date before Christmas?
Probably not. get to speak.
Good morning. Are you Maya Sparks? And will your client waive the formal reading of the indictment in each case?
Yes, sir.
Ms. Sparks, in cause number 25, DCCR 0145, you're charged with the third-degree felony offense of assault on a public servant from October 30th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? Speak up, please. And then in cause number 25 DCCR 0146, you're also charged with a third-degree felony offense of assault on a public servant from October 30th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up, please. And are you pleading guilty because you did what they charged you with? In each of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal? So if I follow the agreement, you can't change your mind later. Do you understand?
Yes, ma'am.
And it looks like the agreement that you've reached in each of your cases is for a 6-year deferred probation. There would be a $300 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case?
No objection.
It's admitted in each case. Is there any evidence that Ms. Sparks is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of guilty in each case freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your cases, and then we will come back at a later date for sentencing. Mr. Nichols, what is the state's position on bond?
Judge, I'm a little concerned about a PSI bond because of the way these cases occurred. There might be an issue that I do anticipate she at the very least being placed on mental health caseload. I don't think it's a competency issue. I've discussed with Ms. Holmes, but I don't know if the court's going to decide that either an ISF or safety program is in the best interest here.
Okay.
The facts in this case involve threatening staff at a school, so it gives me a little bit extra concern. And there was one jail incident in the last week that gave me a little concern as well.
Okay.
Yes, Your Honor. So Ms. Parks and I've spoken with her mother. Her mother is here. On this particular incident, there was a episode. She had a mental episode where she was not on medication at that time. She is compliant on medication now.
Okay.
And we are asking, her mother is taking care of her child. Her child was attending that school that she went to. And so I do feel that if she stays on her medication and stays compliant, that she would be okay. And so we were asking if the court would consider a PSI bond.
I guess the concern is without the probation order where, has she been to Spinal Tap before have you gone through Spinal Tap before? You are a Spinal Tap patient?
She's diagnosed bipolar and major depressive disorder.
Okay. So what I'm going to do, Ms. Sparks, just kind of based on also time of the year, I'm going to reduce the bond, but I'm going to have some very specific conditions on that bond. And you're going to have to follow those conditions Exactly. If you don't, because you're going to have to give Ms. Holmes proof that you're doing some things that I'm going to order you to do. And if you're not doing those things, then I'll issue a warrant for your arrest. We'll get you back in custody until that pre-sentence report's done, and then we know what everything is that you could potentially need. Was there also any type of, or is there any kind of drug issue, or is it primarily mental
It was
health?
just mental.
Okay, so Ms. Sparks, I'm going to reduce your bond in each of your cases to $2,500. If you make those bonds, the conditions of the bonds are that you immediately have an appointment, make an appointment with Spindletop, that you give proof of when that appointment is to Ms. Holmes. So I'm saying the day you get out, you make the phone call, you set an appointment, and Ms. Holmes needs to know when that appointment is. You don't wait a week to set the appointment or 2 weeks or anything like that. You set it the day you get out of jail if you make the bonds. Does that make sense? In addition, I am ordering that you remain on your medication. So now it's not just whether you want to or you feel like you need to, it's a court order. And if you don't do it, you're back in custody. Do you understand? So is her mother okay with her living with her? Where's mom? Thank you, ma'am. And thank you for being here. So I'm going to order that you remain living at your mother's house. You can't go spend the night anywhere else. You can't go anywhere else. You stay there. You go to Spindletop. You get yourself back on track so you can be fine and do this probation and not have any issues. Does that make sense? You are not to go to any of the schools wherever your child or children are going to school. You are not allowed to go there, period. Do you understand? Okay. That's not until I order otherwise. So for now, you cannot go to any school that they are attending. Okay? If somebody needs to pick up and drop off, that's going to be her or someone else. If there's a school program between now and when you come back, I don't care. You don't get to go. Do you understand how serious I am about that? Okay. Any other conditions that you feel
I
like?
think that will cover it, Your Honor.
Okay. All right. We'll see you back at sentencing. You can go back with the bailiff. Okay, I'm writing it all on my docket,
Here, I was gonna say,
so I'll write it again.
you don't have to.
Here, just keep it to the side and I'll do it. Remind me. But I did write it all down.
Okay, thanks.
I redid the paperwork on mine, Judge.
Okay, thank you. Mr. Kimler, what is the announcement on Jeremiah Branch?
I don't know what you mean, warrants, but
Okay, I'll hold it and take care of those when they're ready. Mr. Lewis, I was holding Russell Bean.
Judge, that one, I've gone next door to check, see what Mr. Cole got.
Oh, okay.
But he hasn't, he hasn't.
We're
got it
waiting
yet.
on that. I need to make that note. Okay. What about Denzel Spikes?
Yeah, that was complete.
Okay, I'll take care of that when it comes through. Let's see, on Cecilia Delaney, did y'all get her? Let's take care of Miss Delaney, Mr. Parker.
Forgot about that one.
And this is one where they say outpatient, but I don't have,
Do we think she needs to go for longer than the 120 days?
well, it'll be a civil commitment today for a year. So that's why we had to bring her back, because that was just for the 120. And so now I can do the civil commitment for the 1 year. And even though it's recommending outpatient, I'll make it inpatient so that, because we don't have an outpatient.
All the way down number 78 on the list to be done.
Mm-hmm.
Are you?
I don't
need
know.
one.
I'll go for a while. Yeah, why not? Is it a state jail felony or is it a third? We also need to watch out for
statute.
Okay, yeah.
Because it doesn't look as if it's a public danger.
Right.
I thought we just did some in September.
This one we were trying to get earlier.
Yeah. Oh, that's right.
No, why they have this journal? That's too big.
Sharon would have done it first try.
All right, this is cause number 24, DCCR 1386, and are you Cecilia Delaney? And Ms. Delaney is in court, was previously found not competent to stand trial, was transferred to the John Dunn Behavioral Science Center for competency restoration for a period of not to exceed 120 days. I have received the report from them, and we'll take judicial notice of the court's file, including that report. Included in that is the trial competency evaluation report, which was prepared by Dr. Mary Ann Robinson. The opinion in that report is that Ms. Delaney is still not competent to stand trial, and that further treatment would be required for competency restoration. In addition, there is a forensic psychiatry report that was prepared and by a Dr. Selleck, S-E-L-E-K. Again, the finding with him is that she is not competent to stand trial. Additionally, we have a physician certificate of medical examination for mental illness from Dr. Selleck. The finding in that is that Ms. Delaney does not meet the criteria for inpatient commitment, but meets all of the criteria for an outpatient commitment, with the specific findings that the nature of the mental illness is severe and persistent. As a result of it, if not treated, that she would experience deterioration and the ability to function independently. And in addition, we have a second physician certificate of medical examination for mental illness from a Dr. Lee. The finding is the same in that Ms. Delaney meets the requirement for outpatient commitment based on the nature of her mental illness being severe and persistent, and that if not treated, will experience deterioration and the ability to function independently. That's it. It's another one. Okay, so that being said, well, is there any other evidence with regard to competency?
No, Your Honor.
Not from your state.
So obviously, you guys both know we do not have an outpatient treatment facility in Jefferson County.
Right.
We don't have a jail competency restoration or outpatient competency restoration. So that being said, I have no choice at this point but to find that Ms. Delaney is still not competent to stand trial, and find that commitment inpatient would be required because we do not have outpatient commitment facility, because the nature of her mental illness is severe and persistent, and that if not treated, she would not be able to function independently and live safely in the community without the court-ordered treatment services. And so I am going to order a civil commitment for a period of not to exceed 1 year for competency restoration at the appropriate facility. If there is restoration prior to that, they'll let us know and we'll get Ms. Delaney back. Otherwise, we will wait for their report and have a hearing at that time. Ms. Delaney can go back. Ms. Perazzo, are you ready on Trevon Alexander? Good morning, sir. Are you Trevon Alexander? And Mr. Alexander, I'm sorry?
I said good morning.
Good morning. And so Mr. Alexander is charged in cause number 25 DCCR 0831 with murder. And Ms. Perazzo, what is the announcement?
Your Honor, if we could have just one more short reset so Mr. Smith and I can try to work out an agreement. We have received an offer.
You've received all the discovery?
Yes, ma'am. There are no discovery issues.
Okay, so what I'll do is this will be the final reset. I'll give you some time to do that. Mr. Alexander, at the next court date, if you guys have reached an agreement, we'll take care of it on that date. If not, we'll get your case set for trial. All right, you can go back with the bailiff. Well, that's great, except that he just got it all done.
Okay, I'm just.
Okay, I'll get to it in just a second. It's not even here yet.
Okay.
Mr. Burbank, on Destiny Williams,
Yes, Your Honor. She was in the back.
and Mr. Kimler, I'll get to it as soon as I can.
Want to take it?
Mm-mm. Nope. I don't have it anyway, but.
I don't have the paperwork. Never mind. We're pleading.
For what?
We're pleading to counts 1 and 3.
Okay.
You want paperwork?
What's happening?
I don't know. Do I want paperwork? Is it for, what's it for?
Update.
Yeah.
Yeah.
Yeah. Yeah. I threw you off on the other one. He's gonna have to do paperwork with her.
You didn't throw me off.
I mean, I know it's a new thing, this whole paperwork silliness when we have to do something, but you're getting old. Okay, let's see. So how many are we doing on Branch?
See, he's waiting.
Jeremiah Branch? 8-2 and 8-5. Hand them.
Oh, you still on the judge. I emailed you last week.
Good morning. Are you Jeremiah Branch? Will your client waive the formal reading of the indictment in each case?
Yes, Your Honor.
Mr. Branch, in cause number 25 DCCR 1382, you're charged with the second-degree felony offense of assault on a peace officer from September 17th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? And then in cause number 25, DCCR 1385, you're charged with the second-degree felony offense of robbery from September 17th of 2025. And how do you plead to that charge? Are you also pleading guilty freely and voluntarily? And because you did what they've charged you with? In each of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Kimler? Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've reached with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreements in each of your cases are for 10-year deferred probations, $500 fine in each case. You would be required to follow all of the rules and conditions of probation. And there would be dismissals in cause numbers 25 DCCR 1383 and 1384. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Branch is not competent?
Your Honor, I believe he meets the legal standards for no competency.
All right, sir, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your pleas, find sufficient evidence in each case to find you guilty. However, I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your cases, and then we will come back later for sentencing. Mr. Smith, what is your position with regard to bond reduction based on the nature of these plea agreements? I just printed out a PC.
No.
Let me take a look at this one. Good grief. Okay, so Mr. Branch, is there any criminal history? How old are you?
It has 92.
There is criminal history?
One state jail judge.
I think I'm not going to adjust the bonds due to the nature of the offense. I have taken a look at the probable cause affidavit. I just want to make sure that there's a substance abuse assessment done, make sure there's no issues with that and or any mental health issues that would need to be addressed. If we can also take a look at any mental health issues so that I know at sentencing if there's any other requirements that I would want to impose before release so that we don't end up with this kind of issue again. You can go back with the bailiff. Denzel Spikes, Mr. Lewis. And no paperwork on this?
Yes, shoot paperwork on.
All right, just have a seat, and I don't have it yet. Let's see, we took care of Lazo, right? Okay, give me a minute for. Mr. Rojas, you have a Byron DeQueer. 2 cases.
Yeah.
I'll print the first, if you can print the second, please. Just a second. Good morning, are you Byron DeQueer? Will your client waive the formal reading of the motion in each case?
He will, Your Honor.
Give me just a second.
We can narrow down some of the counts.
I cannot hear you.
We can narrow down some of the counts on the M12.
Okay.
There's like 13 counts.
What do you want to go forward on?
We'll go for first 7.
Okay, state's going to proceed on 1 through 7 in each case. Okay. And Mr. DeQueer, in cause number 23, DCCR 1448, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation July 2nd of 2024 for the 2nd-degree felony offense of assault on a peace officer, and that was a 10-year deferred probation. Is that correct? Yeah, it's just correct that you were placed on probation on that day, right? Are they printing? Huh? I feel like yours is closer, but it takes longer to print than mine. Do we need a new print? What do we need to do? Everything? We need a new TV. We need a new printer. We need new computers.
Thank goodness it's Christmas.
We need new tablets.
Just ask Santa.
Unfortunately, Santa is on the 4th floor of the old courthouse, and I missed that opportunity during budget season to ask for all this extra stuff. Okay. Okay, now, in cause number 23, DCCR 1449, I also have a motion to revoke your unadjudicated probation. This one also shows you were placed on probation July 2nd of 2024 for that same offense, assault on a peace officer, 2nd-degree felony, and that was also a deferred probation for 10 years. Is that correct? Each of these cases allege that you violated your probation, and the state has elected to proceed in counts 1 through 7 in each. Count 1 in each case alleges that you provided a urine sample July 14th of 2025 that tested positive for methamphetamines. And is that true or not true?
True.
Count 2 in each case alleges that you provided a urine sample August 12th of 2025 that also tested positive for methamphetamines and amphetamines. Is that true or not true?
True.
Count 3 in each case alleges that you provided a urine sample August 25th of 2025 that also tested positive for methamphetamines and amphetamines. Is that true or not true?
True.
Count 4 in each case alleges that you tested positive August 26th of 2025 for methamphetamines and amphetamines. Is that true or not true?
True.
Count 5 in each case alleges that you tested positive September 10th of 2025 for amphetamines, methamphetamines, and ecstasy. And is that true or not true?
True.
Count 6 in each case alleges that you tested positive September 16th of 2025 for methamphetamines. Is that true or not true?
True.
And then count 7 in each case alleges that you failed to conduct yourself in a courteous and professional manner at all times when interacting with your probation officer, and that you were argumentative, raised your voice, and became verbally aggressive toward them. Is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 7 freely and voluntarily? And did you plead true to those counts because they're actually true?
True. Yes, ma'am.
I have here on the tablet some documents in each of your cases that have your signature on them that the state has marked as exhibit number 1. Before you signed those documents, did you go over them with Mr. Rojas? And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've reached with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1 in each case.
No objection.
It's admitted. Is there any evidence that Mr. DeCuire is not competent?
No, Your Honor.
All right, sir, in each of your cases, I'm going to find that you entered your pleas of true to counts 1 through 7 freely and voluntarily. Find those counts true. In cause number 23, DCCR 1448, find sufficient evidence to find you guilty, and at this time, find you guilty. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 23, DCCR 1449, also find counts 1 through 7 true, find sufficient evidence to find you guilty, and at this time find you guilty of assault on a peace officer. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence also for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm going to hand you in each of your cases, the trial court certification that shows these were agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, sir. You can go back with the bailiff. Taylon Douglas, Mr. Rojas, at the sentencing.
Taylon Douglas.
All right, you're Taylon Douglas. And Mr. Douglas was previously in court, entered a plea of guilty to the third-degree felony offense of obstruction or retaliation. I've received the pre-sentence report. Has everyone had an opportunity to review that report? Any additions or corrections?
No, Your Honor. Only that court is inclined to follow judge and certainly concur with the answer.
In addition, I have received, and you guys should have been given copies of jail incident reports. Have you all reviewed those as well?
We have them. I'm not, but I take your word for it.
Okay. You don't like to follow rules, do you?
I follow the rules.
You do? You've been following the rules since you've been in jail? Kinda. Okay. So how have you not followed the rules?
I don't know, just whenever, I say like whenever I get disrespected or something like that.
Oh, so when they disrespect you,
I just,
why do you think you deserve their respect?
cause I don't do nothing to disrespect them.
You don't? You don't? Sitting on the countertops, not getting down. Looks like trying to smoke in the bathroom, working out when you're not supposed to be working out, lying about it, saying you're brushing your teeth, teasing and cutting up with and being disrespectful, talking about the officers, act like a little kid. Taking food when you're not supposed to. Calling them some lovely names. B word. Telling them they're white and ugly.
That's what they said, I said?
Mm-hmm.
I don't know, I don't remember.
You don't remember saying that? So here's the thing, how old are you?
19.
19. So you're now on a felony, or about to be, if I follow the agreement, which I don't have to do. You're about to be on a felony probation where you have to follow rules whether you like them or not, because you've committed a felony offense. So you don't get to make all the decisions for yourself anymore, right?
Yes.
Other 19-year-olds who don't do this, they get to go to bed when they want, wake up when they want, eat what they want, work out when they want. You don't get to do those things anymore because you committed a felony offense. And if you continue to act like you've been acting and not follow the rules, however insignificant you think those rules are, you're going to end up right back in here and you're going to end up going to prison for up to 10 years. Do you understand? So your life, you have to make some mature decisions as a young person who's probably not ready to make those decisions. It's going to be a conscious effort and a decision on your part to either do it or not do it, right? What's going to happen if I follow this is you're going to go to ISF. ISF is a 90-day program that's intended to help you make better decisions. But let me tell you what can happen. Between now and the time that you go to ISF, you're going to be in jail. If I get an incident report, it's a violation of your probation. You could get revoked off your probation before you ever go to ISF. Do you understand? And it's happened. Ask them out there. I'm tired of you young people acting like you're acting at our jail. They're tired of it. These people are just going to do their jobs, trying to go home, go with their families, make a living, pay their bills, something that you hopefully will want to do at some point in your life. Instead, they got to go to jail and deal with this. The crap from you kids. But now you're an adult for these purposes. If you get to ISF and you don't make it through that program, or I get incident reports from ISF, they send me those, you're not going to get out. You're never going to see the light of day again. You're going to go to prison. It's that serious. Do you understand? Okay. So I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to pay the $500 fine, and you're ordered to follow all of the rules and conditions of probation, including entering and successfully completing the cognitive track of the ISF program. Again, if you do everything you're supposed to, this is a great opportunity today. I don't want it to all be negative, because you have some very positive things. You don't have a felony conviction on your record. If you're a convicted felon, it changes your life in so many negative ways. You're not going to get certain jobs. If you want to go to trade schools or school or anything like that, or college, you're not going to be able to do certain things, live certain places, all of that. So you still have that opportunity. And if you get everything together and you follow the rules, at the end of your probation period, the case is dismissed. You will never have a felony conviction. This is the chance of your lifetime to change it and live like the rest of us live, okay? The other side, though, is if you violate any condition of probation, you'll be brought back into court, you'll be found guilty, so you would be a convicted felon, and then the punishment can be anywhere in that range from 2 years up to 10 years in prison. You understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Again, I know there's other people out there, there's other young people that are acting up. It's going to be up to you to say, I'm not doing it. I don't want to go to prison. All right? All right, you can go back with the bailiff. Yes, ma'am. Hold on a second.
Before he goes, Judge, in light of the fact that you are giving him an opportunity after deferred on the felony, in reviewing of his incident reports from the PSI themselves and his juvenile history, which is quite extensive.
Yes.
It is my intention to proceed, obviously with a plea bargain offer on those misdemeanors, but I think it would be important, at least with several of them, to have those on his record so that if he is back, we kind of know what we're going to do.
So you won't be able to go to ISF until you take care of those misdemeanors. They'll bring you over on a jail day to get those taken care of. Ms. Molfino will talk to that prosecutor. If you enter pleas on those, great. If you decide to go to trial, then you'll just have to wait to go to ISF until those take care of with the trial, okay? Also, I do want to make sure a condition of your probation is that you are not allowed to be in the possession of a firearm of any type. That means in a vehicle with anybody with a firearm. That means at a house where there are firearms. You are not allowed to be anywhere where there's firearms. If you're living somewhere where there's firearms, you either cannot live there or they have to have those out of the house or locked where you cannot have access to them. Do you understand? Okay, you go back with the bailiff now. Michael Dyer, Mr. Rojas. Good morning. Are you Michael Dyer?
Good morning.
And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Dyer, in cause number 25, DCCR 1340, the state has elected to proceed on the lesser included offense of a Class A misdemeanor assault, and that's from September 9th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Dyer is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of the lesser included offense of a Class A misdemeanor assault, sentence you in accordance with your agreement to a term of 1 year in the Jefferson County Correctional Facility. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to, what?
I'm sorry. Change his mind.
Yeah, California County.
I'm sorry. There was just some alternative offers and
Okay.
he had
We had originally put up
indicated one
paperwork,
and then
right. We originally put up paperwork on the felony, but then
Okay.
changed his mind to the misdemeanor.
Okay, so I'm going to hand you the trial court certification, again, that shows this was an agreement that I followed, and so you've waived your right to appeal. Good luck to you, sir. You can go back with the bailiff.
Yeah, I didn't say it, sorry about that.
And Judge, he had the lowest level of culpability in that case. There was a
Thank you.
individual who's actually doing it wrong.
Thank you. Marco Gomez, Mr. Rojas.
Comment?
I can see that.
Okay.
Good morning. Are you Marco Gomez?
Yes.
And Mr. Gomez, in cause number 21-36534, you're charged with a second-degree felony offense of sexual assault from March 26 of 2020. What that means is if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand?
Yes.
I have here on the tablet a plea bargain rejection that has your signature on it with Mr. Rojas that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 15-year term in prison. You have every right to reject that offer and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand that?
Yeah.
And do you want to reject that offer and have your case set for trial?
Well, would you tell me that I have to sign it today because I don't have, I was gonna get another lawyer.
So here's the thing. Today, I just need to know, there's a couple of things. We'll take them in order. First of all, I need to know if you want to enter a plea of guilty and take the 15 years, or if you want to plead not guilty and go to trial. Okay, so I'll do the rejection and we'll get your case set for trial, okay? Mr. Rojas has been appointed to represent you, and he's one of the attorneys who handles a lot of cases for me as a court-appointed lawyer. With your permission, I can release him and I can appoint another attorney who could begin preparation for trial quicker. Is that okay with you?
Is it the same thing? I still gotta go to trial no matter what?
Yeah. I mean, either you plead guilty and take the deal or you go to trial.
I guess I go to trial.
And are you okay if I appoint a new attorney today? You want to keep Mr. Rojas? All right, so Mr. Rojas will begin preparation for trial and we'll get it set for trial. You may go back with the bailiff. Sarah Jordan,
I don't know what her judge, she said she's gonna either hire Mr. Kimler or Mr. Smith with one more resetting.
okay, we'll just do a reset on Sarah Jordan's 2 cases then. And Gerodrick Randall, the sentencing. I'm about to have to take a break.
We came for a sentencing before and you rejected that because it's some new cases. We have a new plea.
Oh, okay, got it. Okay, so
They're not new cases in this court, no, but he picked up some cases.
okay, so we already went through. All right, are you Gerodrick Randall?
Yes, ma'am.
And so did I just reset it or did I? What is
So
it?
in August, Your Honor, he pled true, and I think at that time we were looking at ISF as our agreement. It was reset for an updated report. Then we discovered he had
Yeah.
two new misdemeanors that occurred in August. And So I
Right.
filed a first amended motion October 22nd.
Okay,
So
we need to go through
to
that.
please to that, and then we have an agreement if the court's okay with it.
Okay. All right. Will you waive the formal reading of the motion?
He will, Your Honor.
Mr. Randall, in clause number 24, DCCR 0543, I have a first amended motion to revoke your unadjudicated probation. And we're going to start kind of all over. I know we've gone through some of this, but we're going to get pleas of true or not true again on all of them.
And Your Honor, with your permission, we've agreed to plead of 1, 2, 3, and then the amended counts of 10 and 11, which cover the several new offenses on misdemeanors, but.
Thank you. So it shows you were placed on probation October 7th of 2024 for aggravated robbery, and that was a 5-year deferred probation. Is that correct? The state's elected to proceed on counts 1, 2, 3, 10, and 11. Count 1 alleges that you violated your probation by committing the new offense of unlawful carrying a weapon May 3rd of 2025. And is that true or not true?
True.
Count 2 alleges that you committed the new offense of evading arrest or detention May 3rd of 2025. And is that true or not true?
True.
Count 3 alleges that you possessed a drug, marijuana, May 3rd of 2025. And is that true or not true?
True.
Count 10 alleges that you committed the offense of unlawful carrying a weapon July 13th of 2025. And is that true or not true?
True.
And then count 11 alleges that you committed the offense of evading arrest or detention July 13th of 2025. And is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, 3, 10, and 11 freely and voluntarily? And did you plead true to those counts because they're all actually true? I have paperwork now, again, on the case here that has your signature on it that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? State tenders number 1.
No objection.
It's admitted. Any evidence that Mr. Randall's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, 3, 10, and 11 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time, find you guilty of the offense of robbery, aggravated robbery. Sentence you in accordance with your agreement to a term of 8 years in the institution.
Judge, I feel like we may have originally pled him to the lesser.
I think we did lesser
robbery.
included.
Let me double check. And it may be because he's one of several co-defendants in that case, and I know at least one of them was pled to the lesser.
I have that we did plead him to a lesser included robbery back in August of 24.
That's correct, Judge. I'm looking at the PSI.
Let me double check with the paperwork, though. Hold on just a second. Can you pull up the original? Well, never mind. It'll probably be in here. Never mind. Hold on.
that down to Judge Robert. Okay, does the state want to,
Yes, Your Honor, I'd ask that I be allowed to amend the motion to take out aggravated, reflect the original.
Any objection to that?
No objection.
So I'm going to go back and just to make sure the record's clear, what you're on probation for is the lesser included offense of the second degree felony offense of robbery. So it's not aggravated, it's the second degree felony. And I'm going to make that modification amendment here on the motion with, let's see. I can figure out how to get all this done. Okay, so that being said, I'm going to find you guilty based on the pleas are true to counts 1, 2, 3, 10, and 11, find you guilty of the offense of robbery. Sentence you in accordance with your agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor.
All right, court's just going to just need about a 5-10 minute break. We'll be in short recess.
All right, the court's in recess.